Good evening and welcome to the Bridgewater Township Planning Board regular meeting for Tuesday, July 16th, 2024. Adequate notice of this meeting has been given in accordance with the Open Public Meetings Act, NJSA 10:4-6. On February 7th, 2024, proper notice was sent to the Courier News and the Star Ledger and filed with the clerk at the Township of Bridgewater and posted on the bulletin board in the municipal building. Please be aware of the Planning Board policy for public hearings. No new applications will be heard after 9:30 p.m. and no new testimony will be taken after 10 p.m. Hearing assistance is available upon request. Accommodation will be made for individuals with a disability pursuant to the Americans with Disabilities Act, or ADA, provided the individual with the disability provide 48 hours advance notice to the Planning Department Secretary before the public meeting. However, if the individual should require special equipment or services, such as a CART transcriber, 7 days advance notice, excluding weekends and holidays, may be necessary. Would everyone please rise to salute the flag?
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Ms. Probst, could I have a roll call, please? Here.
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 Mr. Chowdhury,
Yes, please.
Mr. Atkins,
Here.
Board Attorney, Captain Sarmad, Board Plan, both present. You have a quorum, you proceed.
Thank you, Ms. Probst. If there are any members of the public this evening wishing to address the board on any land use matter other than any application that will be heard tonight, may do so at this time. Hearing none, seeing none, moving on. We do not have any board minutes for adoption this evening, but we do have a few resolutions for consideration. The first one is for Galleria Construction, Block 172 at Lot 11, Buena Parkway and Levant Court. Are there any questions, comments, or changes to the record?
Mr. Chairman, if I might, the agenda that was posted and distributed had a voting record that had been, my mistake, copied and pasted in error. So there's been an updated agenda. It was not posted because it was, changes were limited to our, that's really for internal purposes. So the copy you have in front of you has the accurate voting record for each resolution. So because that error was there, I'd like to read who's eligible to vote, just to confirm before we do.
Thank you, Ms. Probst.
For Galleria and also for SEMA, for both resolutions, Mr. Magora, Ms. Sikora, Mr. Banga, Ms. Chardowich, and Ms. Coelho is here, so she's not.
Very good.
Everyone's in agreement? You have a motion?
I do have a comment on the Galleria one. I know that there was conversation about the temporary fence versus the permanent fence, and I'm not sure that anybody reviewed the minutes. I did try to find the minutes. I couldn't find them myself either. And I seem to remember it different than it was written in the minutes that were portrayed. I seem to remember it as permanent.
If you recall, we directed them to submit an open request for the audio. The next day, the applicant came in, and I spoke with him confirming he submitted an application for a fence permit. So they worked it out amongst themselves, is what I understood. It's an application in for a fence that the neighbor was in agreement with. That was the last I heard of it.
So it should be taken care of.
Okay.
It wasn't done as a matter of this board. The applicant agreed based on whatever they remembered and whatever settlement that they wanted to do with the neighbor next door.
And we know that to be true.
We know that a fence permit was submitted by the applicant, and a fence permit would only be for a permanent fence.
Okay, all right, I just want to make sure that was, okay,
It's taken care of, I believe.
thank you.
Does that answer your question, Mr.
Yes.
Brewer? Thank you. Any other comments, change to the record? Hearing none, could I have a motion to adopt the Galleria construction resolution?
I'll make that motion.
That's Mr. Banga. Could I have a second, please?
I'll second.
That's Mr. Magora. And Ms. Probst, if we could just reiterate who's eligible to vote?
Mr. Magora,
Yes.
Mr. Cora,
Yes.
Mr. Banga,
Yes.
and that's it. The other two members are absent.
Thank you, Ms. Probst. Moving along, we have a resolution for SEMA. That's Block 905, Lot 11, that's 1545 Washington Valley Road. Any questions, comments, or changes to this record? Hearing none, could I have a motion to adopt said resolution?
I move so.
That's Mr. Magora. Could I have a second, please?
I'll second.
That's Mr. Banga. Could I have a roll call, please?
Mr. Magora,
Yes.
Mr. Cora,
Yes.
Yes.
I'm sorry, that's it.
Thank you, Ms. Probst. Okay, moving along to our application portion for the evening. Just a few updates before we move on. If you're here this evening for the Hula Haas application, that has been carried to October 15th, 2024. In case, once again, you're here to hear that, that's been carried to 10/15/24. The second announcement being the municipal yardway site here in Bridgewater, essentially up for review to be considered for as an area for redevelopment. So after all statutory requirements have been met, that will come before the planning board, most likely on the evening of, I believe it's 8/6, so that would be August 6th.
Notice to follow.
Notice to follow.
Mr. Chairman, can I just add to your announcement for carrying the Haas application? That would be with new notice to be provided.
With new notice to be provided. Thank you, Ms. Probst. Okay, no other announcements. We can move on to the one application we have this evening, and that's the return of Gerardo Leonardo. That's Block 17, lots 50 and 51, Mountaintop Road.
Thank you, Mr. Chairman. Good evening, board members, board professionals, members of the public. My name is Michael Silbert, and I'm an attorney at the law firm D. Francesco Bateman, located in Warren Township, New Jersey. I have the responsibility of representing the applicant this evening, Leonard Gerardo.
Welcome
Board
back,
is-
Mr. Silbert.
Board is already familiar with this application, with the applicant having appeared before the board on May 21st, 2024. I would like to recap and re-summarize the application quickly. So the applicant is seeking major subdivision approval together with bulk variance relief for property located at Block 718, lots 50 and 51, more commonly known as 1926 Mountaintop Road. Subject property is a 3.78 acre tract. It is located in the township's R40 single-family residential zone district, and the property currently contains an existing single-family dwelling on Lot 50. The applicant proposes to subdivide the property to create 3 new lots, proposed lots 50.01, 50.02, and 51.01. The existing single-family dwelling will be demolished, and 3 new single-family dwellings will be constructed on each new lot following subdivision approval. As previously mentioned, the applicant seeks bulk variance relief to permit a very small departure from the minimum lot width required for the proposed lots. Minimum lot width required is 150 feet, and the applicant proposes a lot width of 143.58 feet, 147.82 feet, and 141.8 feet for each new lot respectively. Each of the new lots are in excess of the required minimum lot area by approximately 15,000 square feet. So to be clear, the minimum lot area permitted is 40,000 square feet, and each lot is approximately 55,000 square feet. As discussed at the last hearing, the applicant had the option to configure 2 conforming lots and 1 non-conforming lot as it relates to lot width. However, the applicant elected to space out the lot width departures over the 3 proposed lots with the intention of creating the least amount of impact to the neighborhood. As it relates to the requested variance relief, the board's professionals at the last hearing agreed that this was a prudent approach from a planning perspective. The board will also note that the conceptual dwellings depicted on the revised plans have been moved closer to Mountaintop Road in accordance with the feedback and requests made by both members of the public, board professionals, as well as I believe some board members at the May 21st hearing. As a reminder, The dwellings on the revised plans have been shown for conceptual purposes so as to develop the proper stormwater management for the project that would meet the DEP stormwater regulations. While the dwellings are conceptual in nature, they are also being shown to demonstrate to the board that the development can easily comply with all other zoning and bulk standard requirements set forth in the township's ordinance, including lot coverage, FAR, and perhaps most importantly, all side yard, rear yard, and front yard setbacks. If this subdivision is approved, each lot will have a plot plan developed that will show the actual development of the lot. And if the developer or future homeowner decides to construct a pool or patio, for example, they must comply with the maximum coverage and FAR requirements, or they have the option to go before the Zoning Board of Adjustment and seek the applicable relief. This application, as proposed, eliminates a pre-existing non-conforming condition on Lot 50, where a lot coverage of 19.62 exists and where 18% lot coverage is permitted. This nonconformity does not take into account the township's steep slope calculations, where the existing nonconformity is actually much greater than the 1.62% departure. So this application will constitute a significant improvement to what exists on Lot 50. In accordance with the board's and the board's professionals' recommendations from the May 21st hearing, the plans have been updated to utilize the 10-foot contours to develop the steep slope plan and the hillside development information on the plans. As such, the calculations for FAR and improved lot coverage have been updated. Please note that with respect to the density calculations pursuant to Bridgewater Township's Hillside Development Ordinance, I'm referring to Section 126-266A2, that it is based upon the total number of dwelling units on a tract, not on a lot. So as a reminder, the township defines tract as the collective area of parcels, site, and pieces of land or property that lie within the same zone or may be the subject of a current or prior development application. So the reason why I bring this up is the application does in fact comply with the permitted number of dwelling units on the subject tract, which after the required computations based upon the entire tract size actually amounts to 3.25 dwelling units that would be permitted on the entire tract. For purposes of this application, 3 dwelling units are proposed, 1 dwelling unit per new lot. As previously stated, with the exception of the lot with variance relief requested, this major subdivision application is fully conforming with the township zoning requirements. Before I pass the baton off to the applicant's first witness and recall Mr. Stiers, I would like to just preemptively address some of the issues raised in Ms. Alfonso's letter dated July 15th, 2024. First point is that res judicata does not bar making a new application for subdivision approval or modification or enlargement of previously granted approvals. This is very settled case law. This board should be very much familiar with this. This board, I would imagine, has historically heard hundreds, if not thousands, of subdivision applications over the last 50 years involving tracts of land that have been previously subdivided. I imagine that you will hear testimony from our planner this evening in support of C2 variance relief that will justify the relief being sought. However, I just want to be very clear that there's nothing in the municipal land use law, nor is there any case law that prevents the board from granting relief as it relates to the de minimis variance relief being sought this evening. The letter also references what I would characterize as a highly ambiguous private deed restriction dating back to 1957. Of note, this restriction does not preclude future subdivisions or reference any prior board-imposed restrictions so as to bar the applicant's proposed subdivision application. Perhaps most importantly, though, is that this ambiguous deed restriction in question does not, and I want to be very clear, does not run to the public. For example, it does not specify that it is in place to afford adequate protection to the township and the general public. This restriction referenced in the letter should really not be a topic of discussion this evening. It was, however, in the letter, so I felt it appropriate to address it now. I would characterize it more as a last-ditch effort to try to hold up this application, but I don't think the board should play into this, and I'm not trying to be controversial. It's just that there is settled case law as it relates to private deed restrictions and whether they are within the board's purview during a hearing. The restriction referenced in the letter is a private contract, so to speak, private covenants or restrictions of record affecting the use of parcels or land. And I'm going to directly quote from or reference the Cox book, which is this book here that we deem as the Land Use Bible, Section 19-3.4 of the 2024 edition, states that the existence of such a covenant should have no bearing on the board's determination of an application. Such a restrictive covenant is in the nature of a private contract and in no way affects the jurisdiction of a land use board to approve an application and/or grant variance relief. So while I recognize that I cannot control what the board takes into consideration in its deliberations of this application, I would respectfully ask the board to disregard this argument in consideration of this application, since it does pertain to a private contract. And I would ask that Mr. Peck, who is probably familiar with this section of the Cox book and has seen things like this before, as I had just referenced, if he agrees with my analysis, advise the chairman and the rest of the board that it wouldn't be appropriate to engage in dialogue on this in the board's determination of the merits of the application. I do have a couple of housekeeping items, just very quickly. The applicant will provide the board with an updated tax certification prior to the adoption of a resolution, should the application be approved, and that's in accordance with the Planning Department's Report 2.0 dated July 10th, 2024. Also, as a condition of approval, the applicant agrees to comply with Mr. Genova's updated SOAR utility letter dated July 10th, 2024, and will revise the plans accordingly during compliance. I do have two witnesses this evening, Mr. Stiers, who will address the revised subdivision plan, and our planner, Mr. Dougherty, and he's here to address the de minimis variance relief requested in connection with this application under the C2 standard. So I don't know if Mr. Peck, if you have anything you want to add to that.
I think Ms. Alfonso
Oh, absolutely.
is looking to be heard.
Sure.
Thank you. Well, first, I was going to ask Mr. Peck if you wouldn't mind explaining my defeat on the first point.
The race judicata.
Sure, I did agree with him, right? I had a conversation with Mr. Peck, and I understand your point with regard to, yes, it won't be counted as a self-created hardship, right? Because you're going for a C2 variance. But I did want to point out a couple of things, if I can. The Township of Bridgewater has an ordinance that allows, right, gives the planning board the power to hear subdivision applications in certain cases. It's specific in the ordinance that it can hear subdivision cases in the case of a hardship, variance, or for a special permit. So although you're going for a C2 variance here, I do think it's important that we hear some testimony with regard to how they should be heard by this board to begin with and are consistent with that ordinance.
Wait, are you suggesting that the planning board does not have authority to
I think
give
that the
C2 variances?
No, I think but the township does have a specific ordinance that only requires it, or only allows the board to hear those types of applications for the C2 portion if it's considered a hardship variance. So I think you have to give some testimony, right, why this is peculiar.
That's a novel argument.
Okay.
I would
Just noticed
disagree.
it in the-
I don't think the municipal land use law contemplates such a restriction or exclusion. I think the municipal land use law would trump any local ordinance to begin with, and that explicitly makes provisions for both the C1 and C2 variances, and the C2 variances can be granted without having to satisfy some threshold of hardship or something like that. And I would see if our planner, Ms. Sarmad, has anything to add, unless I'm missing something.
I'm not familiar with any ordinance that posts that restriction. As Mr. Peck noted, the MLUL is what governs the different types of variances and outlines what is required under those variances, and then case law has supported what those variances are. So unless if you have that ordinance section, I could give a quick look at it.
126-11, and the reason why I bring it up is because of the recent MACAT case.
Which case?
Cape May, but I don't have the full site right here right now. I'll have to give it to you later.
Mr. Peck, excuse me, Mr. Chairman, may I be recognized?
Yes, please.
So, Mr. Peck, we're hearing this in front of this body because it's a subdivision, correct?
Correct. Zoning board has no authority to do subdivisions.
Okay, so is your suggestion that you're before the right board, but that because you're before this board, we can only grant C1 relief, not C2 relief?
No, I feel they should provide testimony as to why this property fits a hardship criteria. I do think they have to prove that anyway.
The Supreme Court has already weighed in on this. It's the Kaufman case versus Planning Board of Warren Township. This is very clear. This board has heard, and I have represented maybe 24 applications seeking and being granted C2 relief. So I don't know why we're respectfully entertaining this. This is clearly the right board. The board clearly has jurisdiction, and the MLUL, as well as the Supreme Court of the state, permits an applicant to seek C2 relief. And again, I say that with all due respect, but if not here, then where?
So I guess my question for Mr. Peck or the applicant, it's their option, correct, of whether they want to pursue C1 or C2 relief?
Yeah, but a C1 just doesn't apply. I mean, if this is a C2 variance. And the board, I mean, I agree, again, it's a novel argument, it's interesting, and I'm trying to find the code just to read the ordinance, but, I mean, I agree with Mr. Silbert.
I understand.
And his
But
position.
are you suggesting that they should seek C1 relief?
At least provide testimony to that effect, yes.
But I mean, but we still have the authority to grant C2 relief, correct?
I understand, yes.
What
It's a weird little,
I'm hearing from Ms. Alfonso is that in order to pursue a C2 variance, that the applicant first needs to make some threshold showing of hardship with the property, which would be, as far as I know, a first in the state.
Fair.
You know, it's one or the other. You don't do both. And there is, the Kaufman case is the one that first explained the C2 criteria. So, I mean, it's a novel argument, but putting on my judge's hat, I would have to deny that.
thank you.
Ms. Sarmat, I know you had a comment as well.
Oh, I just wanted to note, it would have been helpful if Ms. Alfonso could have provided the section that she was referencing as an exhibit or as evidence, because I can't, 126-11 doesn't seem to exist, and so I'm having difficulty finding it. It's under powers of the planning board.
Yeah.
So I believe that's probably stipulated or a copy of what the MLUL sets forth. But I don't see anywhere in that section under powers of the planning board stipulating that there has to be a requirement.
Well, yeah.
It almost is a moot point and irrelevant because the MLUL, as well as Supreme Court precedent, would surely take precedence over an outdated ordinance if the ordinance for some reason does say that. I assure this board that the board has the power to grant C2 relief, as it has done, or at least heard cases on, probably hundreds of times, and the applicant will put on its application, and they've made the determination for this that C2 relief is the proper avenue for the applicant to pursue.
Yeah, and there's also some language before that, in that same section. It goes, the planning board has the authority to the same extent and subject to the same restrictions as the zoning board. So basically, it's, to me, my interpretation is that the planning board, if a subdivision or site plan requires C variance relief, bulk variance relief, that basically the planning board can step into the shoes of the zoning board and exercise the same kind of powers. So, it's 126-11B. Yeah, no, I mean, in my opinion, this board clearly has jurisdiction over the application.
Thank you. If everyone's okay, I think, I just have a couple of other points. I just wanted to put that in the record.
Go ahead, Ms. Alfonso.
I did want to know, we put our letter in, which provides the whole summary of the subdivision of these lots. And I understand, right, the board and the applicant doesn't feel that should be considered here, but I do feel, while this isn't a question for the board can consider the desire of the neighborhood and the desire of the predecessors entitled to this property to maintain the wooded character of the neighborhood and of this property, which is very wooded.
But wouldn't that play into the proofs that the applicant has to show for the negative criteria, where the applicant has to show that there's no substantial detriment to neighboring properties?
Yes. So I think it's important for the board to note that these deeds all the way back from 1967 contain this covenant and references to it to maintain the wooded character of the properties and of the neighborhood. And if you look at Google Earth, if you drive by, it's extremely wooded. You'll notice. Okay, and with that, I feel the board has the right, and the duty to look at the locations of the homes that are proposed on the lots to make sure that they're not going to eliminate trees. As we heard in the last hearing, they weren't sure how many, but it was over 30.
Well, the board does have the power to attach reasonable mitigating conditions on the grant of any variance. So buffering is certainly something that the board often considers in connection with grant of bulk variances.
And the neighbor, Ms. Tekene, has really asked for that and for a couple other things. She wanted to have more of an ongoing and open discussion with the applicant. It was difficult, and they were not able to come to an agreement, which is why I'm here today. She is hoping that there is still possible resolution here, or at least, the board will consider her concerns while considering this application. First, she's asked now that the proposal be changed to allow for 2 conforming lots with 2 single-family
Chairman,
homes to be
I'd
constructed.
like to object to this. The applicant's time
maintain-
is now to put on its application. If Ms. Alfonso would like to make an objection on behalf of her client, certainly more than welcome to do so, but allow the applicant to present its application to the board,
This is
please.
becoming an objector's
Okay.
case now, which should wait until the applicant has put their testimony on.
I agree, and I think that if there are any questions that are pertinent to discussion, we can hear them when that appropriate time comes as well.
Okay, I apologize. I did, we have asked for time to speak with the applicant and delays, and that was met with, we're going ahead.
They're allowed
That's
to
why I
go
wanted to
ahead
make
with their
sure.
application.
Sure?
Their application. So they don't have to delay.
Yes. But the board then can consider.
You haven't even heard his
neighbors'
testimony yet.
Opposition. We've heard a lot of testimony.
We've heard some, we have not heard it all.
Okay. Thank you.
Thank you, Mr. Alfonso.
I just have a question for Mr. Silber.
Sure.
Your client, Mr. Gerardo, he's the one that purchased this property in 1957, or was there another intervening owner?
It was, I believe.
Or multiple intervening owners?
Owners, that's correct. I purposely, and Mr. Councilman, I don't know where you're going with these questions, but I very purposely didn't want to discuss any of the details of the deed going back to 1957 because I didn't want to waste the board's time, and I wanted to move ahead with our
No,
app.
I understand. I'm just trying to create a fact pattern, and the fact pattern is that between May 17th, 1957, and the owner, whenever ownership, when did Mr. Gerardo take ownership, approximately?
Pull the deeds out. I've looked at so many deeds for so many things the last couple of days, so it's not fresh here.
All right, well, let's just say,
Recently,
If that's what Ms. Alfonso,
2015? Okay, and there have been at least one or more owners between 1957 and 2015?
yes.
Okay, thank you.
Mr. Silver, thank you for previously updating us to where we are this evening. Please bring up your first witness.
Thank you. So my first witness is Mr. Stiers. He was sworn in at the last hearing.
Nancy, do you remember where the exhibit numbers left off?
I have it here, I believe. I believe we left off at A3, which was the steep slope overlay.
Okay. So this would be A4?
No, this is from the last meeting.
Oh, okay.
This is A1 and A2.
Oh, okay, cool.
So A1 was the colorized landscape plan, and if you recall at the last hearing, Mr. Stiers prepared an overlay or an alternate plan, which is A2. And Mr. Stiers, your license remains in good standing, and you recognize you're still under oath?
Yes.
Great, thank you. So, Mr. Stiers, why don't you show the board where we were at the last hearing?
So this is A1 that was presented to the, or shown to the board. This was the colorized version of the originally submitted plans. If you recall, the houses were back roughly 120 feet or so. As I testified, there's a ridge line right here, and we set the houses on the ridge line. From that point, I guess shortly before the first meeting, the neighbor contacted our client regarding some of the, I guess, objections to the plans. And so what we did was we didn't have a chance to fully revise the plans, so we made the overlay to present to the board. So what we did, the overlay A2 showed the three houses moved approximately 100 feet to the north or closer to Mountaintop Road. We did go through all the testimony as far as the plans, and I think we responded to many of the comments from your professionals, and then essentially ran out of time. So that was an opportunity to update the board based on our testimony and discussions, and also an opportunity to reply to your professionals' comments all at one time and come back to the board tonight. So that is what we've done. So that those revised plans now show essentially the formal three houses in the locations that are 100 feet towards the front. And then, like I said, we took care of some of the comments. I know your planner suggested having a conservation easement. We have added that to the plan, so that corresponds with the rear yard setback, so that's a 75-foot conservation easement. We did have plantings in the rear here. I did actually have a meeting with the neighbor, Seaman Tekkenham, I'm sorry, on June 10th. And we did walk the site. She just did express some of her concerns to me, and I thought I tried to incorporate them. One of the things was with the conservation easement, one, we wanted to leave it alone. So we removed these trees, and what we did is we supplemented along the side property line that's common to Ms. Tekkenay's property. Her property is to the west here. So you can see on the revised plans, there's an enhanced buffer in this location to buffer the new house from hers. I think one of the other things that we talked about is the houses being closer to the front. That opened up her view a little bit better. The valley is obviously to the south here, so there's no blockage of the views that she could potentially have. Any of the trees that are here now are existing and would remain. Removal of the house that's currently there now gives a little bit broader view of the valley, so I think it would be an enhancement. The rest of the items were, like I said, the comments from your professionals, and we did get an updated review from Bill Burr, and you can see that probably half of the comments are satisfied, and some are just meant.
Is there, Craig, is there anything in the Genova July 10 memo or the Burr July 10 memo that you can't comply with, other than you've testified, you know, to?
If I could just go through a couple items in Mr. Burr's report, and I'm sure he has my back if I miss anything, but, so can you just confirm, based upon the relocation of the conceptual dwellings to the front of the property, that there's no disturbance of over 30% slopes in accordance with the hillside development ordinance?
That is all in the back. There is some disturbance, I believe it's 10 to 20 to 30, but we can disturb that. But all the 30% slopes will remain untouched.
Okay. And that was on page 4. I'm moving back to page 3. So the discussion or the topic of sidewalks, it was at least discussed at the last hearing. We're requesting a waiver to provide sidewalks along Mountaintop Road. Is that correct?
Yes.
And why is that request being made?
As far as I know, I've been down Mountaintop a few times. There are no sidewalks anywhere on Mountaintop.
Okay.
Another note is that these revised plans actually provide reduced coverage from the existing conditions. So despite 3 houses, there's less coverage proposed than there is currently. So that's another net benefit for the project.
So the proposed dry wells have been relocated to the front of the new dwellings. Is that correct?
Yes.
Can you just point out on proposed lot 51.01 where that dry well is proposed?
It's not specifically shown on the exhibit, but they are located, there would be 3 in the front of each one of the houses.
Okay, so Mr. Burr pointed that might have been mislabeled, or just, we failed to label it, but we'll revise the plans and label it, but it is there?
Yes.
Okay. And so you did absolutely touch upon this, but your opinion is still that the pervious asphalt in the front is the best option for the applicant. Again, I know these are conceptual, but that's your professional opinion?
Yes, because the other thing is, you know, as they brought up tonight regarding trying to keep the lots wooded, pervious pavement is actually right underneath the pavement. If we were to put a fire retention in, swell, whatever, basin in, that's gonna be next to it, that's gonna be more possible clearing of trees. So what we've tried to do is keep this condensed as possible. And, you know, as we said, everything, the back, almost half of the property is gonna be unchanged as far as tree removal. So the tree removal is just gonna be in the areas of the dwellings and the driveways, and that's it.
Speak into the mic. Okay. I'm just going to see if there were any outstanding comments from Ms. Sarmad's report. So I spoke about this in my introduction, but is it your opinion that the density calculations is based upon the total tract size as opposed to the individual lots?
Yeah, we've been doing
And the total tract can, after the computations or the calculations you did, provides for a density of 3.25 dwelling units. Is that accurate? Okay. And we're proposing 3. So would you agree that there's adequate space under the hillside development ordinance to accommodate the 3 proposed dwellings within the tract?
Yes.
Okay. I don't remember if I asked this at the last hearing, but the applicant is proposing what I have characterized as de minimis lot frontage relief, lot width relief. My question to you, Mr. Stiers, is as an engineer, do you think that the public or the neighborhood would be able to discern a difference between a conforming lot size or a lot width and a non-conforming lot width when the differences are as insignificant as what the applicant is proposing this evening?
No, and as I said at the last hearing, the approximately 150-foot lots is somewhat consistent with what you're seeing coming down Mountaintop. And especially on the other side of the road, I believe that they're less than 150, and that's an R50 zone, which requires 165. So through this area right here, the lot widths are much less than required.
So is it fair to say that the only way somebody could tell that the lots as being proposed were undersized, so to speak, at least with respect to lot width, would be if they were to take out a tape measure and measure it? That's the only way you'd be able to tell?
Yes.
Okay. So you've already done this, just want to make sure it's on the record. I believe you already put it on the record, but all the calculations in the site plan have been updated with the revised submission.
Testing, testing.
I just want to make sure that the calculations throughout the site plan have been corrected and updated in accordance with the homes being moved forward.
Yes.
Okay. So in Ms. Sarmad's report, I'm looking at page 10 under steep slopes 1A. It says the applicant should testify on how this demarcation can be accomplished as a more permanent visual marker. Ms. Sarmad, I believe, is referring to where the 30% slopes kick in towards the rear. What was your opinion as to a visual marker?
I mean, they are on private property, so, I mean, you're going to have the conservation easement along the back, so that's going to be in your deeds. Most likely, we can put iron pins at the intersection of the conservation easement and the property lines to demarcate that, but as far as a fence or something like that, I think it's a little bit excessive.
So we can stipulate, of course, to providing in our deeds that the conservation easement is in existence. We can even reference, should the board approve this, the board's approval, so that there's a track record, so to speak. Just touching on something that we spoke about at the last hearing, a couple things. So to accommodate the board's concerns, the property deeds will reflect the requirement to maintain the pervious pavement as a condition imposed by the planning board throughout the duration of its existence. Would you recommend that we do that?
Yes, they would have an operation and maintenance manual that would be filed with the deeds.
Okay, and we can even separately include that in the deeds, just so there's protection. The driveway apron in the front, that won't have any pervious pavement though, right?
No, it would stop at the right-of-way.
Okay, so the township's not going to have any responsibilities with respect to that. We did speak about our agreement to supplement the existing street trees wherever necessary. We can work with the board's professionals on that.
Those are actually on the revised plans already.
Great, thank you. And the last thing that I raised at the last hearing is that you didn't feel that that a developer's agreement would be necessary, that we can put these conditions at least with respect to the pervious pavement as well as the conservation easement in the deed. So I guess my question is, do you think it would be necessary to have a developer's agreement?
No.
Okay, I have no further questions. Thank you.
Thank you, Mr. Silber. Thanks, Mr. Stiers. I'd like to open up to the board for any questions.
I have a couple questions.
Ms. Sikora.
Can you explain the grinder pump again? That has to do with sewage?
Yes. So basically, it's uphill. So the sewage coming out of the house would drain by gravity to the pit, fills up the pit, and there's a pump in the pit. So that pumps it out to the road. And there are there's probably 15, 20 houses that are on Mountaintop that are under this similar agreement. So it pumps out to a force main, comes down to this manhole right here, and then it becomes gravity, goes down the hill.
And it would be the homeowner's responsibility to maintain the grinder pump.
Right now, all of those, or I'm pretty sure all of them on Mountaintop have license agreements that the township maintains them until 2027, at which time then it would become the responsibility of the property owner. So what Tom Genova is saying is it's a new lot. Basically, we're going to, cancel that agreement. Right, so now instead of the township maintaining it, the property owner would maintain. They're all over the place. I mean, it's like a packaged little system, and they work very well.
Got it, so this homeowner would maintain early versus the other ones because it's a new, got it.
Yep.
Yeah.
Is there any kind of like operations or maintenance manual or anything like that that goes along with the grinder pump, or something that should be like noted in the deed?
No, I don't think so.
Okay.
No. I mean, it's not something, like as far as the maintenance of the stormwater, this is more like, it's almost like your hot water.
Okay. If it malfunctions, you'll know it.
Call a plumber.
You'll know it quickly.
Yeah.
Just, a question on that. Does a pump like that have any warning that it's about to wear out, or kind of it wears out and the homeowner has a pretty big problem and has to fix it urgently?
I mean, it is a pit. It's probably, a lot of them are between 50 and 100 gallons. So, and there are alarms on it. So, it floats to a certain point, pumps out. But if it gets to that level, then it'll set off an alarm. And I believe that, you'll have a light on there and everything. So, yes, before it starts spewing on the ground, I guess what you're thinking is that there are alarms when it gets too high. And that,
So the concerned homeowner would pay attention to warning signs and get professional assistance quickly.
Yes.
I think what we're looking at is something similar to a homeowner who has, relies on well water. When their well water pump dies, it dies. Normally dies hard.
I'm sure there's like a septic tank, they recommend a certain number of times a year that you get it pumped, or a certain number of times, I'm assuming that would fall
Well,
under
it
the
should pump itself.
Yes, got it.
Could you review for the board what the type of maintenance is included?
I don't know specifically, but, again, as long as it's running, I guess theoretically, if the power goes out, then it's not pumping, so. But there are, safety factors on it. Like I said, if it fills up to a certain point, there are overflow alarms and things like that.
And it's designed to keep the level relatively low, so there is flex if there's a power outage or the pump fails. There's flex built into the system.
Yes.
Okay.
I mean, an example, we did Somerset Tire Service down at the stadium. So that entire facility is on a grinder pump. A little bit bigger, obviously, but the same exact velocity. It fills up, drains all the way up to where the target is. So this is a miniature version of that.
Number of trees added, removed. I know you talked about not putting some in the conservation, putting them on the side now. Do you know, is that for you, like the number of trees that you're planning to remove versus add?
We have 30 removed, and we comply with the township ordinance to replace them. And that chart is on the landscape plan.
Okay, and then two more. So I was the one who brought up the pervious pavement piece because I've had some troubles with pervious pavement in a facility that I run. The thing, that I had brought up is specifically the edge between the road and the driveway. And I forget what you had said of how far in we're gonna, you would have regular pavement before pervious pavement?
It's roughly 10 feet. You can see it's hatched on the revised plans.
Okay,
So you're gonna have regular pavement up to the right of way. So it's gonna be a regular apron, and then, the pervious paver, that's what it could be, it's just switching the pavers. So that's still, so, you see, properties that have pavers for driveways, it can be concrete, it can be pavers.
okay. Because if it's concrete, well, more of my fear is the damage done to the driveways, and I wouldn't want people calling the township saying, hey, the salt and the plows are getting into my driveway because well, I've covered those things. So, I know what the damage can look like. And then I know that we were talked about putting it in the deed. I know also many homeowners don't read their deeds in detail. And knowing that this might change hands multiple times. Is there a required permit, I don't know, maybe Ms. Harmon can answer this better, for if somebody were to pave their driveway? Say that again? So if somebody was gonna go pave their driveway in Bridgewater, do they have to get a permit ahead of time?
If they were over on their impervious coverage, probably.
Okay, so it would trigger then, because this would be a coverage issue, because that's why we're putting impervious pavement here.
No, theirs is not based on coverage. Mr. Stiers can probably elaborate on that.
Yeah, I think there's also a reality that needs to be overlaid there, which is when a person paves driveways, they're just paving driveways. So even if you were close to impervious, unfortunately, I think that's something that would probably happen and may or may not be caught after the fact.
It happens sometimes. While we're on the topic, because I think that brought up a good point, I think it was discussed or touched upon at the last hearing, but I think, Mr. Stiers, you should go through the alternatives of why the pervious paver driveways are being proposed from a stormwater quality perspective versus a bioretention basin, which you noted about tree removal, but maybe clarify for the board, kind of what your options are for stormwater quality.
Well, technically speaking, we, as I said before, we're reducing the coverage. So therefore, there's technically no need for groundwater recharge or water quality. So, but again, the last thing is the quantity. And I actually tried to eliminate them, and I wasn't sure, like I said, I wasn't sure which way the board was going. But, it was very close as far as meeting the criteria of the quantity. And making those pervious was like the last thing. I mean, you're talking about tenths of a CFS, which is really nothing, but on paper, you need to show that. There probably could be some options, but again, I'm trying to limit the amount of tree removal. So one of the options would be to put like a real thin line retention swale that, you push the driveway to one side and it just goes into the swale. But, again, this meets the criteria of what the state requires, so I kind of just left it at this point. If this is approved, the applicant comes back to us to, develop the properties, maybe we look into that and, get into more detail, but, excuse me, this is again conceptual to show the board that it does work as far as the subdivision is concerned.
Would have to come back, so, and it could in theory be pavers instead of,
This is almost like a worst case scenario.
Right.
The worst case, best case makes sense, because again, you're limiting the tree removal. So, it does work, it is recharging back in the ground. But if we did do a small swale that didn't remove any additional trees, maybe we go with that. And, obviously work it out in the bill as far as, those final designs. But, it's not gonna, I don't think it's gonna affect what the board is looking at. I mean, you're gonna see maybe a grass swale, but it's not gonna be something that you need to cut back.
thank you, that's all I have.
I have one question, please. Yeah, I'm actually more curious about the pervious payment. So what you are saying that for the regular payment from the street, there'll be 1 inch offset, or it will be flush with the pervious pavement and it will be flushed? The concern is always on the maintenance, as many of us basically are expressed it. So will the maintenance requirement will be part of the deeds, or it's not necessary? Mr. Peck?
That seemed more engineering. Could you restate the question?
The maintenance of the pervious portion of the driveways will be part of the deeds as a conditions, or it is not?
Well, it can be. I had asked before if the maintenance of that should be in the deed. So that's certainly
Okay,
something
so
we
you
could
are
add
already
as a
considering it,
condition.
right? Okay.
We agreed to do that.
Okay.
Okay, yeah, I think.
How is that enforced later? How does the township township has no authority to,
It doesn't unless it's coverage related, but this is stormwater
so
related.
then why do you put a condition in the deed if you can't enforce it?
We would include, I think they're talking about the maintenance manual. We were requesting that there
Yeah.
be a maintenance manual included, and then it was attached to a deed, then the homeowner would be aware that they had pervious pavement, because otherwise they may not be aware. They may not follow the maintenance manual, but it's intended just the way that you'd have a stormwater management basin maintenance manual.
Why wouldn't there be similar deed about the grinder pump?
Should be, actually.
I mean, I don't see the differentiation between the two.
Do you guys, any objection to having a notice in the deed for that one lot with the grinder pump?
No objections. We can include it.
Okay.
Under the new arrangement, the new property owner would be responsible. So why wouldn't you want the property owner to understand that in a deed, a clause in the deed about the grinder pump versus just the driveway? Why wouldn't you? So then why the clause about the driveway? I just think the grinder pump is more important to the property owner. I understand, but my point is, if the applicant, through you, Mr. Stiers, is suggesting that you want a deed clause to inform the property owner that the driveway material has to be maintained, why wouldn't you want there to be a clause about the grinder pump?
We will include a clause based upon your recommendation. We have no objections to it, so we'll include one in the deed along with all the other references that we stipulated.
I have that noted as a condition, should they get approval.
I have a, go ahead.
While we're on the grinder pump, there's an existing agreement in place with the township. Do you know what that entails?
It entails that it's the township's responsibility to maintain it up until 2027. Being that there are new lots being proposed, and based upon the report issued by Mr. Genova, we're agreeing to essentially terminate that agreement early and take over responsibility of either the existing or a new grinder pump to be installed in association with this subdivision application. One thing I'll just note is that for a major subdivision, the board chairman will get to sign off on the deed to ensure that the deed does properly reflect any of the things that we're stipulating to including this evening. So I just want to make sure the board has that assurance that they get to look at the deed before we do anything.
Mr. Chairman, I have a couple of questions, and maybe it's following up on what Mr. Stiers just spoke about. Mr. Stiers, you spoke earlier about, I'm not sure exactly what topic you were speaking of. You were saying that the application, quote, complies with state regs. I wasn't sure what, I don't remember what you were speaking about. And you also talked about the, I'm trying to use, this was what I thought you mentioned, that the approach to determine the overall tract, and you were speaking about the entire lot size, and you were determining lot coverage. What was the, you said that there was an approach that the township had established, and could you refresh my memory? I don't remember what you were referencing specifically. Mm-hmm. Okay, the steep slope is what you're referencing then, okay. For the steep slope. Right. And then, but that's not the only provision of the township requirements for subdivision. Well, you made mention that you make through that handwritten set of instructions that there's an approach to determining, again, I'm not using your words, lot coverage and right? It's sort of what you implied.
Well, there's the total land.
It's what Mr. Stires is referencing is section, or subsection, or I'm sorry, chapter 126, section 266. The handwritten notes that Mr. Stires referenced mirrors the ordinance, however, it has diagrams, but the calculations in that written handout that I looked at is the same thing as the ordinance. And just generally speaking, what the ordinance sets out to do is calculate the density for the overall tract. Whatever that is, take that number. So we had 3.25, rounded down to 3. Then you calculate the FAR and the lot coverage that's permitted on each individual lot based upon the steep slopes.
Okay, so now I understand that. Is that what you were referencing? Okay. But that's not the only ordinance that an application has to be measured against, correct?
Well, I was speaking to the steep slope ordinance in the.
I understand, but now my question is moving on. That's not the only ordinance that an application has to be measured against.
Still unclear of the question.
So is the steep slope ordinance the only ordinance that an application has to be measured against?
No, you have to take into account the entire land use ordinance.
Okay. So you were referencing the steep slope ordinance in that commentary. Okay.
Yes, because that was one of the comments in Catherine's review.
Okay. Could we talk about the lot size now?
Sure.
So it's, what zone is this again?
R40.
And that is what minimum lot size?
40,000.
And the existing property is how many square feet?
There are 2 of them. Lot 50 is almost 85,483. And 51 is 79,408.
And the proposed 3 new lots are what square footage?
54,876, 55,323, 54,692.
And the width, lot width, requirement and proposed?
Required is 150. 50.01 is 143.58. 50.02 is 147.82. 5101 is 141.80.
Okay. Ms. Armit, you have a report that I'm looking at back from April, and you have a table on page 4.
Yes.
And on the first section of that, again, have the description and the lot area and minimum lot width, and then there's a another variance that's noted here. Could you describe that again?
Yes, so kind of the genesis of why Mr. Silbert and Mr. Stiers have brought up the how-to on the hillside development calculations. And that is that exhibit, well, it wasn't entered as an exhibit, but that, which I was provided tonight as well, clarifies basically, and it literally says, the following is a step-by-step description of how you, the applicant, shall proceed with calculating these things. Because from my perspective and how I interpreted the ordinance and what appears in that zoning table was that you could apply the steep slopes, the hillside development calculations against the lot size. And it might just be me, but also it was just how I was interpreting the ordinance, which included to meet the purposes, goals, and standards set forth in Article 34, the applicable provisions of the zoning ordinance relating to minimum lot sizes and density of the development shall be modified in areas of steep slopes greater than 10%. So as I read it, I thought there was two categories. There was the lot size and the density. But as kind of clarified by this how-to, as well as Mr. Stiers, who has, I think, some anecdotal experience before the board for many years utilizing the hillside development calculations, it really, the lot area is not a consideration of the hillside development calculations. It feeds directly into that density calculation. So I was mistaken, and that second row showing the after HDC, after hillside development calculation, really is not applicable here. So, it all goes back to my interpretation that there was not only reductions for hillside development calculations for steep slopes for FAR and impervious, but also for lot size and density, which I thought made sense for a case like this. But in reality, the lot size is really related only to the total overall density of development, which they do meet, and Mr. Silbert has noted a few times tonight.
Just to preserve the record, I'd like to enter that into the record as an exhibit. We can mark it as A4 and can identify it as the original steep slope calculations.
We should, hillside steep slope development calculation prepared by John E. Leon Cavallo.
Hold on.
And
Want to spell it?
I start from the beginning again.
Sorry. Hillside steep slope development calculation prepared by John E. Leon Cavallo.
Thanks.
And it's not dated.
And Mr. Peck, if I may borrow that just to provide a copy to members of the public, if it's okay, Ms. Sarmat, I'd like to borrow that just so that members of the public can see what I'm referring to, what we've just made part of the record.
While they're doing that, Cavallo?
Leon Cavallo, Leoncavallo.
I guess I have one more question for Mr. Stiers. Mr. Stiers, I asked about the lot width, and you described the lot width, that each of the three would be less than the 150 feet. Is there a scenario where there could be change to any of those widths to have one or more of the three new lots conforming?
I think we briefly discussed this at the last meeting, that we had a pre-app meeting with the former planner, Scarlett Doyle, and we did mention that. Do we make two of them comply? And the last one exacerbated. And between us, we felt that averaging them out, so to speak, because you can see that it's kind of a little bit of the lot width and the lot area, so you can kind of make them all relatively the same. And that's what the little bit of the deviations are. So that's where we came in. So after our discussion, we kind of split them, not exactly, but.
I remember, but I'm asking you, can that be done?
Yeah.
And what would that,
Except,
I'm just asking, let me finish asking the question. What would that look like in your opinion? Which lot, if you could make two conforming lots by width and one, not, what would that lot width be, approximately?
what would be the non-conforming one?
Correct.
About 16 feet,
A little more than that,
17.
18 feet or so.
And which of the lots do you think that would be?
Well, of course, with the neighbor to the west being here with an attorney, I would say make the westerly lot the conforming lot.
Okay, thank you. Thank you.
Any other questions?
I just have a.
You mentioned a wetlands consultant. You mentioned a wetlands consultant. Has he had the opportunity to walk the property?
He did not. I did contact him today. So I said, kind of, if we get it approved tonight, he would probably be out there in the next week.
Okay, just something we did in the past is that if wetlands are determined, they should be delineated so that they're not
Well,
wiped out in the future.
obviously, if they have an impact on the application, we probably return to the board.
Yeah, we did ask a previous applicant to actually put signs up on their wetlands to show where they were. Thank you.
Mr. Atkins?
Thank you. Just a point of clarification. You mentioned earlier there would be 30 trees removed. Is that correct?
30 removed, yes.
30 removed. Is that net or is that for planting additional? Okay.
So then you have computations based on the township ordinance for your replacement. And the replacement does comply with the requirements.
Because it seems that on sheet 3, at least 48 trees are to be removed.
They have to be over a certain size.
Over a certain size?
Yes.
So what's the size then that are
6 inches?
6 inches? Okay. And so that's where the 30 comes from?
Yes.
Okay. Thank you.
For those of us in this room that don't have a set of plans, could you briefly just show essentially where the buffering of trees is or will be proposed?
Check myself first. So we have, there would be, we kind of revised it from this kind of generic. So we have a, probably about a dozen evergreens in this location. Then there will be 3 there's kind of a mix. They're like dogwoods. So there's kind of a land, because there's a landscape replacement or requirement. There's a foundation requirement, and then there's replacement. And then on top of that, the street trees. So we've kind of taken into account all of those between the mix of the replacement trees, the landscape trees. We even have foundation plantings along the front of the house. And then we did call out what we felt were street trees and then supplemented on top of that. And then just to finally answer your question, so they're again, spread out along the property lines, but they're a better mix this time. And then the bulk of the trees are obviously along the westerly property line.
Okay. And are there any existing deciduous clusters that are going to remain, and where would they be?
They're not necessarily clusters. They're spread out through the property.
Okay.
You know, if you were to see it from Google Maps, it looks like a completely wooded lot.
Right.
But if you were to walk it, not so much. It's just got a very good canopy.
Sure.
So the trees are spaced out. It's just that, you know, again, the canopy above it's pretty nice.
Okay. And I'm assuming the proposed buffering would conform to the neighborhood and what the neighborhood looks like today for the
Well, I think
established
the other
lots.
thing is that we're fitting in amongst what's there now.
Okay.
So, you know, you don't want to start crowding stuff out, and then all of a sudden, you know, one is going to kill the other. So you want, you know, a healthy growth of the landscaping as well. So we're trying to fit it in to what's there. And like I said, most of the removal is in and around the houses, and even the grading is relatively tight to the houses. It's just, you know, unfortunately, it's the removal of the old house that creates a bit of most of the disturbance.
Right. And most of the trees that are in the rear along the slope, a lot of those are set to remain.
Oh, yeah,
Okay.
yes.
Okay.
They will be in that, they said that conservation easement is following the rear property line, or rear setback line.
I had a note, if we could just go back for a second from the last meeting here about dry wells. Mr. Burr's obviously not here this evening to speak about it, but are they adequately sized, or will they be adequately sized for maximum improved lot coverage?
Yes.
Okay.
I mean, they are sized right now, and the computations have been added to the plans. So based on what you see for the houses, they are sized for those houses. If somebody does anything bigger or in addition to, they would have to supplement those dry wells.
And lastly, we talked about the pervious driveway surface ad nauseum. But again, in Bill's absence here, essentially, because the maintenance is such an issue, would you be willing to work with Mr. Burr's office while that's being constructed?
Absolutely, yeah.
Okay, could we make that a condition of approval, Mr. Peck?
Yeah.
I do have some other questions, but I believe they're going to be reserved for Mr. Doherty. Any other questions?
I just want to have a clarification. You said that you'll be removing 30 trees, right? So when you replenish it, it will be equally distributed in all the 3 lots?
Like I said, you can see on the plans, there's different criteria for the types of trees that are being planted. So there's replacement, there's landscape, street trees, and then also foundation plantings, which are the bushes or shrubbery. So between all of those, we comply with the ordinance. So it's not only replacing the 30 trees, we're replacing well beyond that.
Well, my question is actually not related to what you are doing now, but suppose 1 or 2 of the tenant will like to sell the property and new tenant will do something else, and then again the same tree issues comes in individually rather than as a whole lot. That's the reason I'm asking you the questions. So if it is equally distributed, whatever your criteria for all the 4 different types of the trees are, so if it's equally distributed, at least it will be remain the same constraint or same basically advantage to all of the 3 tenant.
I would say that the tree plantings would have to comply with the approved plans.
Okay.
That's what you're getting at?
Not exactly. I'm just, suppose after the 3 owners, 2 owners sell the property tomorrow, and a new owner comes and they want to develop something else, then again the 3 calculation will come into the effect. But if you basically design now to have almost equally distributed the 3 densities for each and every lot, that problem will not occur. That's in future.
I don't know if I'm addressing this, but if 30 years from now, a homeowner wanted to change the landscaping on one of the 3 lots, they would still have to comply with the township's ordinance if they wanted to change the landscaping. So while they have flexibility to change it, the ordinance still would prevail. They'd have to go to the township, depending upon what they're doing, and seek a tree removal permit. Is that accurate?
Yeah.
Okay.
I don't know if that's.
I think once it's all planted, I think, then you really go back to the ordinance.
Ordinance again.
For example, you're permitted to take 3 trees down a year, no matter the size, and you can also document that, if the tree is dead. So you kind of fall back to the ordinance again, as opposed to the development itself.
Yeah, I should know. I'm a chairperson for a shade tree board. Okay, thank you.
It's a trick question, though.
Okay, thank you.
I have a few. While we're talking about the tree removal that Mr. Atkins had brought up, I did look at the removal on sheet 3 versus the table on sheet 7, and there's at least one missing tree that's shown as removed, an 8-inch cedar in front of the existing home that's not shown on in the table. So even just one missing tree from the table kind of sparks an interest, and maybe let's look at that.
We can check it, yeah.
And double check that, and if there's any additional requirements, then or additional plantings required, then we'll have to compensate. But I want the board just to be aware of that. It was a question, a good catch from Mr. Atkins, but I just wanted to look through, and there's at least one that's not shown on the table. So
I still have the stick figures on my desk, so I can go back and check it.
okay, I can understand how that can be difficult. As far as other questions that I had to go through, as mentioned, I agree with the way the hillside development calculations were applied. I do not believe, as noted on Table 1 on page 4 of my review memo, that the variance for lot size can be contemplated. It's not something that the hillside development calculations contemplate after looking through that exhibit. And so I don't believe there should be a variance imposed for the lot areas there. In looking at while I'm on bulk regs, in looking at the kind of the scenarios that's been posed about having the lots be somewhat congruent in size rather than have two conform in lot width and then one seek a variance for a greater deviation from the 150-foot width, it does appear that the as proposed for the homes, the size of the homes, that the side yard setbacks could still be complied with. They would be reduced, obviously, but it looks like the total and combined side yard, the single and combined side yards could be complied with, but they would be lesser. And from I think the question was posed to me at the first hearing, but I do believe that the congruent nature of the lots will probably have less of an impact than having one outlier that would have a greater deviation. I think visually, it probably will be unapparent to most people, passerbys. I think the greatest deviation is for the proposed lot 51.01, which is 8.2 feet, and the lowest one being 2.2 feet approximately. So visually, I don't think you'll be able to notice it. As far as the street trees provided, I do appreciate from the first hearing, it was brought up that to show compliance with the street tree requirements along Mountain Top Road, they were seeking to utilize existing trees on the site, which is fine, that's allowed, but I did want them identified, and Mr. Stiers went through and he did update the plans to show those, and I would just request that the applicant or ask if they would agree to a condition that upon inspection, when inspection's done after, when construction's underway, that if any of those trees are in poor condition, they're dead or dying, that they would be replaced. Any of the trees identified to comply with the street tree requirements.
We can absolutely agree with that.
Thank you. And then the biggest thing, and I think it was kind of still something that was on my mind from the first hearing, and I think probably took up a big chunk of the time before we ran out of time that night, was about the pervious pavement driveways. And I think, Mr. Stiers has given the background to why that alternative was chosen and has been proposed. I do think there's still quite a bit of uncertainty about what that's going to look like. I really probably would like to see something more, no pun intended, more concrete. But I mean more so about the options that they have for pervious pavement, whether it be pervious concrete, pervious pavers, because the maintenance does differ between those two. They have their differences in maintenance and their differences in issues that arise. But I do think that that is something probably that either this board can advise as part of the resolution. I think Mr. Burr should definitely be the one who monitors the next steps with that. So even if there hasn't been a decision made by this board, that Mr. Burr can look at what they offer as far as their overall stormwater management plan, their options for construction for pervious pavement or pavers or whatever, or swale, as Mr. Stiers had brought up, and any kind of maintenance manual. And Mr. Burr can look through those and determine if they're adequate or not. And I'm certain that he would hold them to a very high standard to make sure that it's adequate.
Would be acceptable?
Absolutely acceptable.
And
Make it a stipulation of the
I'm putting it in
agreement
as
that
a
you work
condition
with.
that,
Okay.
yeah.
yes, I think it should absolutely be a condition.
The selection of the pervious pavement and then the operations and maintenance manual are subject to the reasonable review and approval of the engineer.
Stipulated as said.
Mr. Chairman, something that Ms. Sarmad said prompted a thought. Mr. Stiers, I think you had said earlier that the proposed lot coverage under this plan would be less than the existing.
Yes.
Could you go over those numbers one more time?
It comes out As shown, the existing in square feet, 16,771. And then if you were to add together, 50.01 is 5,118. 50.02 is 5,382, and 51.01 is 5,356. And
What does that add up to?
that comes in just shy of 16,000.
Okay. If the, thank you, if there are only two lots in this, if this was only divided into two lots, two building lots,
That is, 'cause it's 2 lots now.
but if the other portion was developed into with a single-family home, similar to what's proposed, what do you think the lot coverage would be?
Probably pretty substantial, because, I mean, I think I testified that the 2 houses would be between 10 and 12,000 square feet.
And that's the size of the home, you mean? Okay. Okay. And what type of, since we've spent so much time talking about the driveway, what, under that scenario, what kind of a driveway material do you think would be utilized? Similar to what's proposed here?
Yeah.
So you just have larger building footprints would be the only difference?
Probably twice, 3 times as many dry wells.
Okay, thank you.
And while we're talking about impervious coverage, just to confirm, were the pervious pavers included in the improved lot coverage?
Yes.
Good, okay. And then the only other comment I had, Mr. Silbert posed a question to Mr. Stiers related to kind of a visual marker for the conservation easement. Similar to a lot of the kind of conditions that are being imposed regarding attachments to a deed, the conservation easement, I think, is important in that it's protecting that area from being disturbed. The steep slope area in particular, it's over 30% steep slopes back there. And I think Mr. Shires had noted that he would agree or recommend an iron pin or something to that effect, that a fence would be too much. And I definitely would recommend that be a condition. Over time, the conservation easement could get lost in its importance to each subsequent homeowner. So it just becomes a piece of paper, whereas when you live on your property, that's more, your day by day. So I definitely think a visual marker that demarcates where that starts would be helpful to the future property owners.
In the past, the board has seen other similar applications where we proposed a monument of some type, something more permanent, regardless.
I think anything a surveyor can, put down and then identify in the future is helpful.
One thing they do in Franklin is they put the pin in, and just in front of the pin, they put a 4x4 post up. So it's kind of that little, helps you find it better. It's kind of like Catherine said, it's that delineator. So, the pin you'll never find unless you're a surveyor.
Right.
So the post would help you, find that thing. So, it's just that I'd like to keep it open if we could. So if we put the posts up, you have that demarcation, but you also keep it open for the view.
Once again, the proposed condition I have is that any wetlands areas, as well as the conservation easement, would be delineated by some sort of monument, the selection of which is subject to the township engineer.
Fair enough.
Great.
Any other questions?
I have no other questions. Thank you.
The board have any other questions? Okay. At this time,
I did have a question, Mr. Stiles. So, can you remind me of lots, the character of lots 49, 66, 65, 64, kind of the surrounding lots themselves, mainly specifically around the setbacks and the character of those properties, and how that's differentiated against what's proposed here.
Could you run through those numbers again?
49, so the one corresponding next to lot 50, and then the ones behind it. Really, we can kind of just focus on the ones that are on mountaintop. But I'm just curious to get your perspective on the setbacks and the overall character of those properties. Yeah, 49, just like, yeah, just in this, just in this area.
5.
Thank you.
Correct.
Yeah.
It looks like lot 49, though, seems like at least visually, a longer setback. Is that, can you calculate that? Because I think based on the new proposal, you're gonna be fairly closer to the roadway itself. Even, right, but you're saying that it's gonna be very similar, right, but if you, you know, if you're to calculate that based on where you are on the road versus where you just put your pen, visually it looks like a less setback than, you know, potentially lot 49 and even lot 52.1 and 52. Mhm.
Everything to the south of that is now being unchanged. So that's, you know, there's a few reasons that why we moved the house is 100 feet forward.
Okay. And then with regards to lot 49 and I guess the properties behind, what is the overall lot area for those properties from a characteristics perspective?
49, 49, actually, these 5 lots were part of I think this subdivision that was brought up in 1957. So these 5 lots were all 150 feet wide. And then the previous owner, Mr. Damio, I guess really assembled the 2 lots that he has now, and then also sold 75 feet to lot 49 to create what it is now. So lot 49 got larger, lot 50 got larger, and 51 was the size that it is now. So what they essentially did a lot line adjustment between those 3, and essentially what we're doing is almost putting it back to where it was.
Okay. And can you just, for my knowledge, lots 52 and 52.1 seem a little different than the lots that are currently, you know, in existence currently. You know why that is the case?
52 and 5201?
Mm-hmm.
Looks like they were subdivided similar to this.
Philip, following up on Mr. Banga, Mr. Stires, the houses, what's the setback, the adjoining property to the west and the 2 to the east that he's referencing? What do you think is the setback from the road at the edge of pavement?
The road would be whatever we have plus approximately 10 feet. probably close to 90 feet or so. 80, 90 feet.
So which lot?
Our lots.
No, I'm talking about the lot to the west of the subject property. And then the two lots to the east.
Can't be right. I'm sorry, I got the wrong scale. There's no way that's right. So 49 would be approximately 100 feet to the road. Same thing with the lot to the east.
And then the lot setback for the three new houses you're proposing.
To the road, like I said, would be about 90 feet.
Okay, thank you.
Thank you, Mr. Phelps. Any other questions from our board?
Nope.
At this time, I'd like to open up to any members of the public who wish to pose questions regarding Mr. Steyer's testimony.
Good evening, Dana Caparoso, 65 Twin Oaks Road, the one to the southerly portion. Oh, sure. Dana Caparoso, Caparoso. And I'm directly to the south. I was the one who expressed concern over the stormwater runoff. And also even still with the tree removal, in terms of Mr. Steyer's, you said you would replace it with shrubbery, landscaping, et cetera. And you did mention the canopy there. Now, there's a lot of oak trees in the area, a lot of older trees that are, I don't know how tall they are, but quite tall, absorb a lot of water. What impact, if any, could the removal of those trees have? And are you distinguishing with how many trees are going to be removed that are, the 80-foot tall trees, the 20-foot tall trees, and how many? And how can you compensate for the removal of those trees with shrubbery and landscaping?
All I can say is that, yes, I mean, based on the ordinance, you're supposed to determine or identify the trees based on their diameter, which is what we did. I mean, it really doesn't take into account the height of them. So the diameter is then, you have to replace by a certain number based on that diameter. And that's what I said, that whatever we removed, we met and compensated based on what the ordinance required. As far as your property is concerned, like I said, we took into what you said, we moved the houses forward. So from that high point on the property going towards you, nothing's going to change. With the exception, we're actually removing the house, so that's going to go back to natural conditions.
Your environmental impact statement, it just said a lot of trees would be removed. I know there was one portion that talked about the type of soils there, that if there's a lot of removal of vegetation, that there's rapid runoff and erosion. Are any of those areas impacted, or will any of those areas be impacted by the removal of these trees? I understand you're saying it's based on diameter, but if the ordinance only allows removal of 3 trees per year,
that's
normally.
Different,
Right.
portion of the ordinance.
But like if I wanted to remove 3 trees or dead trees from my property, I would have to take that into consideration, get a permit, whatnot. What is the impact to the environment when you're just removing trees because they're in the way and you're not considering how tall they are, you're just considering diameter?
Well, we are, again, we're restoring, I mean, it's not the same size tree, but at some point it will be, or conceivably could be. But we're also providing stormwater management, again, is all going towards Mountaintop. We actually did have actual soil testing, which kind of contradict, because what is in the environmental impact statement is general conditions. It's off of county soils maps and things like that. Subsequent to that, we did do actual soil testing, which is the percolation on the soil is, on the site is still pretty good. And that's the reason we proposed the dry wells. So the recharge on the site is probably better than in the general characteristics that we got from the county soils maps.
I tried going on the town's website. I didn't see any of the updated plans, and even what was discussed the last time with the overlay. I'm not sure if that's available or not. Because the information that's on the town's website is still from April 15th. That was the most recent submission. So I'm kind of shooting from the hip here and hearing what I heard today. I didn't have the benefit of reviewing any of those plans prior to today's meeting because they were not on the website.
They're available to the public. It's not a requirement that they be on the website, that's a courtesy. My understanding is they should be on the website, just because they were provided to be. But if they're not there, you're always welcome to come in and use them in the office.
Okay, and the agenda said either come to the office or you can click on this link for the documents, and that's what I did, and they weren't available. So that, again, that's one of my concerns was, again, with the size of the trees. Is there any way to go through the property and determine how many of the larger trees are going to be removed? I mean, is there a way to limit the removal of some of the larger trees as much as possible?
Again, the only place we took them down was where we had the proposed houses and the dwellings, and the grading. We tried to preserve as many of the trees as we possibly could.
And you also said you're moving the dry wells towards the front of the property. Will that have any impact with regard to the stormwater runoff and the drainage towards the south of the property, where the rear of the property?
Originally, in the previous set of plans, we did have them in the back of the property, or back of
Right.
the houses, over the top of the hill. So again, we've moved the houses 100 feet forward. We've moved the dry wells from the back of the houses to the front, which essentially preserves that ridge line. So everything going to you with the removal of the existing house is going to get better drainage-wise.
There's no existing house right now above. I just have vegetation and trees above my, I'm at lot 64. I'm directly
So there's,
by that one that has no
oh, you have the vacant.
no improvements whatsoever.
So you're probably this one.
Yep. And you said there's going to be a 75-foot conservation easement. Is that 75 feet between the rear property line and my property line?
Well, your property line and the rear property line are the same thing.
Right, but I mean where that
75 feet,
steep slope is.
75 feet towards mountaintop from the rear property line.
And are you leaving the trees and vegetation that are there, or are you removing them and replacing those?
We're leaving everything the way it is.
Okay. Is 75 feet sufficient to preserve that slope, so I don't have to worry about mudslides and rocks and everything impacting my house that has been there since
Nothing's
1963?
changing from the high point towards you.
Okay.
So the high point going towards mountaintop is where all the development is going to be.
Right, but there's still going to be improvements on the lot that were not there or not there now. So that's what I'm concerned about. Is that going to be a sufficient easement, whereas it's going to prevent like excessive stormwater runoff
Again, the stormwater runoff from the
and
development
drainage?
towards the north.
Right, but it's still, once you develop it, rain has to find a path, and it's going to follow gravity. My house is downhill, so that's why I'm wondering, what is the impact going to be? And is 75 feet conservation easement where you're leaving all the
No change.
all the vegetation? Okay,
Everything's staying the same.
Okay.
The plantings we had here, we took them out. So
Okay.
it's going to just stay as is.
Okay, so you'll leave the existing vegetation, it's going to be undisturbed? Okay, thank you. I don't have any more questions, thank you.
Hi, my name is Susan Willett, Willett. I live at 1871 Mountaintop. I'm on the other side, the side that you just said the water would go to.
Side?
Across the street.
Oh, okay.
Across the street. I don't live directly across the street from these properties, but it does impact. So I have a couple of questions relating to trees. I've watched development on that street. I've lived there for nearly 20 years. I've gone through this process before, and most of the people cut down all their trees. I've seen it happen too many times. When you put in the new trees, are these ones native? Or are you just, I mean, how are you determining what trees are going in to replace that? You know, to replace the 30s?
That's a list in their ordinance, and we have to pick from that list, which are native.
Okay, that's good. And how do you, and I don't know if this question is for you or for you folks, I just don't understand, and I'm sorry, because I didn't really come prepared to talk too much. How do you ensure compliance? Like you were talking about these great things about putting it in the deeds, et cetera, et cetera. You're supposed to get permission to cut down trees, you're supposed to get permission before you put down a driveway. How do you ensure compliance? Because I've watched it. People paving driveways, and I've watched trees being cut, and I didn't know that there was anything anybody could do because it just happened. And I'm watching this character of our neighborhood, which I bought my house because of the trees and the old growth. How does that? I don't know who the question is. I'm asking this too. I don't know how you ensure
These are conditions of
compliance.
approval that we put in place for this reason.
It'd be conditions, and then the zoning officer or code enforcement or anybody else who, you know, if you noticed something that was possibly in violation of a condition of approval, you could call the zoning officer and they would investigate, and that's where the
After
enforcement.
the trees have fallen down.
But I'll, if I may, I'll go one step
I just want to know,
further.
I'm just trying to, because I'm as.
No, I'll explain the process. I'm going to give you a very honest answer. Presuming that these homes were built, a certificate of occupancy is not issued until the entire project is properly inspected.
Right.
And that means everything. And that would mean all these conditions and everything that was agreed to. So at the time when assuming there was approval, these properties were built, you and the community can rest assured that whatever is in the plans, whatever we agree to, that is what you will see
Right.
at that time. Now, what happens a month later, a year later,
Right.
5 years later, 10 years later? And this is where I'm going to give you the honest answer. We have standards in this community for how you're supposed to maintain your property. When you can pave when you do not exceed impervious coverage. You can cut down trees subject to, a certain limitation in terms of the caliper and/or the number per year. Can I tell you that every one of our 15,000 properties in this town abide by that all the time? No, they do not. The challenge that we have as a community is we absolutely want to maintain the integrity of our zoning code, but at the same time, we are not Big Brother. We're not sending drones up in the air and checking how many trees are on every property. So, there is a balancing act between homeowners being able to do what they reasonably want to on their properties, as they have rights to, but at the same time still following our laws. But in all candor, can you be assured that these numbers of trees 10 years from now, 20 years from now? The honest answer is no. What you get in a hearing like this and what you get from a proceeding like this is a commitment to the build out is going to be well defined and monitored and will be the basis for issuing a certificate of occupancy.
I appreciate that, and I didn't know there was such a thing as a manual, because if that really is something that happens, then that can hopefully help. And you talked about a monument to mark where the wetlands were. I wish that had been in the properties near us too as well. So I appreciate what you folks are doing and asking these questions. By the way, if you ever want to know any more about grinder pumps, I have one. I can answer your questions about what that all happens. Those are my questions for now. Thank you for your time.
Okay. Is there any way I can show something?
Oh, you'd have to ask Suzanne. has an electronic exhibit she wants to show.
Suzanne, can we do screen mirroring?
She has like a screen.
That's okay. Thank you. If I can just show it like this. I can bring it up to the board members if you like, but it's just a copy of the current tax map showing the lot widths and dimensions for block 718.
How are we going to,
I have a question, I promise. I did want to just make sure that you could.
but also, I think that should be marked as an exhibit. Well, you could provide a copy of that.
We may have an exhibit. We brought one that is the tax map, so I don't mind if you want to use our exhibit. We haven't presented. I wasn't sure if we were going to, but that's, I think it's sheet 63. So
You know, that's
it is marked up.
fine. I think she just needed it for demonstrative purposes.
I don't know if you want to put it in.
Call it
the record.
A6.
It's an objector's exit, whatever you want to.
Or 01.
Yeah.
Oh, it's not good.
Oh, not that, because it's all marked up. And it's not just showing, I'm trying to show the whole neighborhood. I'm sorry? I can't, it's the current tax map of the township of Bridgewater.
The tax map sheet is included on the cover page of the site plan, but it does not have the width.
It just doesn't have the dimensions marked.
Visually could help assist the board if they want to have the
Sure.
key map on the cover sheet.
Describe it.
Well, we'll call it 01, but you have to provide Ms. Probst with a copy of that tomorrow, if you can
Okay.
email her a PDF.
Mr. Stires, if you could just take a look at this and show the board, this is lots 50 and 51, right? That's the lots that you're proposing to subdivide into 3 lots. And you already talked about this, but lot 50, what's the lot width?
224.74.
Okay, and lot 51?
207.74.
Lot 49?
It's like 250.
225, I think, I'll give you that.
Sorry, yes.
And what is that, 48?
150, and then 47 is 150.
And then going behind to Twin Oaks, what's the lot width of lot 67?
310, I think. Is that correct?
I think it's like 330, hard to see. Over 300, let's call it.
Over 300.
Okay. Lot 66,
150,
65,
221,
and then the last one in that big block, right, is 64?
207.
Okay. So all of those were 150 or more?
Yes.
So when you were talking about the lots in the neighborhood that are under 150 in lot width, you're really talking about across the street only on Mountaintop?
In the neighborhood, I would not consider Twin Oaks to be in the neighborhood.
You don't consider that to be in their
No,
neighborhood?
'cause number one, it's probably 200 feet down, so you're looking far over top, so I would not consider that the neighborhood. I would consider the neighborhood Mountaintop. And
Okay.
So essentially, you have 47, 48. The 3 we would create would be approximately 150, so there's 5. The 2 to the east are less than 110. The one to the east of that's 177, and then if you do go across the street, you're in the 130s with about 10 houses.
Okay, but that you mentioned is what zone is across the street?
Or 50.
Right, and behind us, lot 67, lot 66, 65, 64.
or 40. But again,
And then-
R40 would be more restrictive, and yet they're smaller lots, which are across the street.
May I
mentioned-
ask a follow-up question? So the different sides of the streets are in different zones, which is not unusual. But in this specific spot, it feels like those R50 houses are each a little more like an R40 house.
If that's smaller. And then the other thing to note is lot 49, lot 49 and lot 50, where there was a lot line adjustment amongst them of the previous property owner. So technically speaking, you had 47, 48, 49, 50, all 150 lots. So what happened was between 49 and 50, there was 75 feet conveyed to the existing property to the west, which created the size that it is now. So like I said, all of those were part of a single subdivision, and all the lots were 150 each. Which again, creates that consistency in the neighborhood.
That's not what the title report showed.
You correct me if I'm wrong, but if you left the lots as is, the lot sizes would be 224.74 and 207.74, where you could put massive homes on them, compared to splitting between 3 and being more comparable in size.
A lot of times, that's what I also say, is that the board is really controlling the size of the houses. So if you didn't approve this, I mean, for 3 years, we worked on a house for the applicant before he decided not to do it. That was 12,000 square feet on lot, replacing the existing house. It was absolutely massive.
That's already
Conforming.
Yes.
And with no need to come to a land use board.
Exactly. Building permit.
But why didn't he decide to do that?
I-
At the last hearing, it was discussed that it doesn't fit with the market conditions and doesn't fit with the neighborhood at that
That's why
size.
I didn't do it. So he's looking to do something more consistent with the market conditions.
Right, and he could do that with 2 lots, correct?
But they wouldn't have to.
Need to put a 10,000 square foot house on it just because he might have the lot coverage capability.
The ability is there.
And the application's what the application is. We're here for a major subdivision to create 3 new lots. That's what the applicant's here for, is spend all the time and money to get here. I understand like the hypotheticals that the applicant is really trying to do something that's consistent with the character of the neighborhood, and the board has the opportunity to control that.
I guess, right, I'm arguing that it's not consistent. I'm trying to show that it's not consistent, right, based on all of the lot widths and the lot sizes in the area. But if I may go on.
This is
you
a time for
mentioned-
questions, though, right? We're still at questions.
We
Yes.
have a
Only
direct,
We still have
yeah.
another.
questions only.
Questions based on his testimony.
You mentioned the square footage of the proposed homes is 4,000 square feet. At the last hearing, you were gonna see if that's correct.
Roughly speaking, yes.
Okay, is that the maximum that the homes could be proposed? As I understand their concept plan.
There are no architectural plans. This is purely conceptual.
Is that a good estimate for what the maximum
I think
size of the home could be?
footprints that are shown are appropriate for the house, for the lots.
Okay. But it's not the max, they could be bigger.
They can go up to what's permitted on the zoning chart.
Right, and I'm asking you to estimate, because you estimated that you could put a 10 to 12,000 square foot house if it was 2 lots, as it is now. Can you estimate what it would be if you have 3 lots maximum?
Second. So the maximum floor area ratio for each of the lots, based on the steep slopes computations, is lot 50.01 would be 6975. Lot 5002 would be 5958, and the last one would be 6161. So that's all they could do, the maximum FAR.
Okay, so 6,000 to 7,000 square feet. Right, okay.
And keep in mind, the applicant would have to come back before the board when we discuss a structure.
They do not have to come back before the board if they're complying, correct?
Correct.
So you don't plan on coming back to the board with floor plans and architecturals, correct?
Correct.
So let me look at this a slightly different way. We have a certain amount of property, whether it's divided in two, divided in three. It sounds like we can have about 19,000 square feet a house. If there's two of them and they were theoretically split about even, that's how you get almost 10,000 feet a house. Otherwise, if you split it among three, that's how you get to your numbers that are in the 6-7 range. Am I looking at it the right way?
Putting it in simple terms, yes.
Okay, right? Because you know the percentages are going to be this are going to work no matter whether it's one lot, 2 lots, 3 lots. I mean, theoretically, you could combine this thing into one, and then you could build a conference center practically, right? But going back to realistic market viability, current conditions are supporting homes up to the 3,500 to 4,000 square foot range.
I'm not into it too much, other than what I do. But I would say that you're probably correct.
And a home to be built that's larger than that, even if it could be, there's not that many buyers that can afford that or that have the needs for that, right? Yeah. Okay. All right.
I have one last question, I promise. Did you have a chance to see what the current condition is of the existing home? Is it structurally okay? Is there any way that home could be saved?
I did not go through it. I was in the back of it when they were doing the soil testing. I mean, it's very overgrown. Basement doesn't look like it's in good condition. So, I mean, again, money's, you can do anything with money, so it's kind of a loaded question.
I understand. Thank you. That's all I have.
Thank you.
This witness, thank you.
I just had a follow-up question. Regarding that 75 feet, where is that recognized, that 75 feet that was given from block 50 to 49? Is that recognized somewhere? You keep referring back to it, and I'm just curious.
I do have a copy of the original subdivision, which has the 150-foot lots. And I believe there was a deed, 77 or so.
There is 1957 and then
Yeah, but that's the original.
1967.
I think
67.
late 70s, I think there was a transfer of 75 feet between two properties.
There were multiple re-subdivisions or lot line adjustments done between the 60s and 70s between not necessarily this property, but amongst the current configuration of the lots. So.
And they're all amongst family members, to be honest with you. I think it was, like I said, Mr. Damio and a relative.
Okay, that closes the public portion for this witness. Mr. Silbert?
I would like to call my planner if the board will indulge me.
We do have some time.
Okay, great. So, Mr. Dougherty was sworn in, and it remains under oath from the last hearing, so I'm just reminding him. He did not testify last hearing, though. So if you would be so kind to put your credentials and educational background on the record in the field of professional planning.
Certainly.
You're already sworn, but
I thought you were sworn already, but
we might have
can
done
do it
that.
again.
we can swear me in.
It never hurts to do it twice. Do you swear or affirm that the testimony you're going to give in connection with this hearing will be the truth and nothing but the truth?
I do.
All right, could you state and spell your name for the record?
Alexander Dougherty, last name is Dougherty. Professional planner, my licenses are current and good standings.
And if you would, please place your educational background and credentials on the record as a professional planner.
Certainly. My education is at Rutgers Blaustein with a master's in city and regional planning, concentration in development and redevelopment, certification in public policy. I testify on this capacity on a weekly and daily basis. The professional development officer for APA New Jersey, supervising planner for the town of Dover. I've testified before this board, was accepted as a professional. I've presented at the League of Municipalities, State Development Redevelopment Conference. I'm immersed in the world of planning.
So, Mr. Chairman, I would ask Mr. Dougherty's or acceptable to you and the board that he be accepted as an expert in the field of planning.
Are there any objections to Mr. Dougherty's qualifications?
No objection.
Please proceed. Thank you.
Before you start, I was just wondering if, in the time that you've been sitting in the audience, if you had a chance to look at when that ordinance was adopted, referenced earlier this evening. I believe it was 126-11B.
Yes, I have. My understanding was 1985.
Okay, and there's just a little part of a case I want to read. I'll ask you to identify the case if you're familiar with it. It was adopted, or it was decided in 1988. Although personal hardship was not a permissible basis for the old C variance, nor is it now for a C1 variance, it may be a basis for a variance under C2, provided that the evidence shows the purposes of zoning would be advanced and the benefit outweighs the detriments, as in all C2 cases.
This is Kaufman versus Planning Board of Warren Township, Supreme Court 88.
It is. So this case was decided after the ordinance, of course. And do you know? Can you just touch upon that case a little bit?
Yes, certainly. I do want to just also point out for history, C2 came out in 84. That's when the MLUL was amended. It was 84. This ordinance that we were talking about, 126.11, was 85. And we looked at Section B of that. But if you read further in Section C, there is some additional language where it talks about other variances that may be applicable in the subdivision and so forth. Because prior to 85, really 84, I mean, let's face it, the MLU was adopted in 84. By the time municipalities catch on to what's happening and it's implemented, it's new, it's in the scene. But prior to that, there was only one C variance, and it was a hardship variance. But not everything is applicable to a hardship. And then the C1 has its own categories as what defines a hardship: topography, the lot width, inability to cure it. You have existing structures on properties that may not be in compliance with the zoning setbacks, and in that regards. So there's some hardships related to the physical features of the property and existing structures on the property. But the C2 recognizes the idea that there's some dimensional relief that can be granted that doesn't necessarily fall under the ideal scenario of a hardship. And how do you prove the hardship? So the C2 came out in 84, and it took a while for municipalities to understand what the C2 was. So the Kaufman case that came out in 88 really sets the stage for what a C2 is. There is a lot of similarities with the Kaufman case, what we have here. I'd like to tell the board that this case has been heard, it's been ruled, and and we can go home tonight. But the Kaufman case was for a minor subdivision. Now, every municipality can define a major and a minor as their own way. In Dover, a minor is a 3-lot subdivision. Bridgewater, it's a major. A lot of towns, it's 2 and 3, but there are some distinctions to be made. But this case, Kaufman, was a minor subdivision. I believe it was Doug and Mary Lou submitted an application originally for a minor subdivision where they also wanted to comply with the lot width requirements for their application. In order to do that, one of the lots that they were trying to create would be what we call a flag lot, where it would have a really narrow strip and it would come back and open up like a flag on a flagpole. Now that is really frowned upon in planning and overall neighborhood fabrics and development. Nobody wants a house
behind them in their backyard, you know, that kind of narrative. And you don't really see too much of it. Generally speaking, municipalities have shunned away from that, and that's what we talk about, the underlying intent of the zoning, characteristics of the neighborhood in that regards. So they came back with a revised plan, similar to what this application is here, where they took the lots and they found it was more acceptable to have 2 lots with the deviation of lot width. That way they were more in conformity with each other than versus one conforming, one in lot width not. So when I say there's some real parallels here to those two, this application of Kaufman, there really is, because we could, as we've testified to, and as the board is aware, we have adequate width to make 2 of these lots conforming, and there'll be a deficiency of approximately 17 to 18 feet for the other lot. Question here is that 17, 18 feet visually impairing, or is the deviations of 6.42 or 2.818 or 8.2 deviations in lot width visually impairing to the neighborhood fabric? And as a planner, and I believe your planner mentioned it as well, and the prior planning administrator, this is the better alternative than having one lot noticeably deficient in lot width, to where from the public realm it would be noticeably visible. We did have a discussion just a moment ago about what constitutes the neighborhood makeup, and in that regards, planning really is difficult unless there's a really hard physical delineation and a use to be balanced. When does the public drive down the street and know that's the R40, that's the R50, that's the, you know, it's really hard to differentiate that. Typically, it's easier when it's an industrial facility versus, you know, a commercial brick and mortar kind of amenity downtown. You know, those are, you can really tell when you're in a different zone. Residential is fairly difficult. Typically, we don't really allow, you know, fences in the front yard either. So where do you have these hard front yard delineations, landscaping, that kind of ordeal? But to pick up 8 feet or 6 feet or even 2 feet with the visual eye, you know, I'd be hard pressed to say someone can do that and say that's so visually invasive that, you know, it's more substantial of a detriment here than the benefits that an application like this could bring. With that being said, this application, you know, talking about the trees, talking about the steep slopes, talking about impervious coverage, densities, FAR, and the likes, I want to bring everybody back home. We're here for a lot width variance. No other variances on the table. This has been looked at and reviewed quite a bit. We have, again, for the proposed, it is a major subdivision. We're classifying it. There are existing, as is today, 2 lots. We're creating an additional lot, one other lot. But in order to do that, we are doing some adjustments with the prior lot line to have a visually aesthetically pleasing neighborhood fabric going up Mountain View. So with that being said, the variances here again, we have a lot deficiency width being proposed of 6.42, 6 feet, 0.42 inches for lot 50.01. Lot 50.02, that deficiency in lot width is 2.18, and then lot 51.01 is 8 feet, 0.2 inches. So those are the variances on the table. I do want to just point out the exhibit that we were referencing before, that zoning map, the one I just gave you with so marked up. Thank you. So, we're going to put this on the easel. And I believe you had it previously marked.
No, we never did, so that'll be A6. We'll call that partially colorized tax map.
where the lot width requirements are 165. To this side is the R40 zone, which we are currently in. And our properties, respectfully, are right here, 50 and 51. As we've talked about the knoll, the mountain, is back here, as we've heard, nearly 200 feet in elevation above it. I would not classify this as the context of the neighborhood. Individuals that live below, this is what you see when you drive down the street. That's your neighborhood. What happens behind a property does matter, but in this particular case, this layout, this topography, this is a distinctive neighborhood. Though we do have a split zone here at the road, as I just mentioned before, driving down the street, will you as a pedestrian and regular Joe Schmo going down, going home, do you know that that's the R40 and that's the R50? No, unless you know zoning, you know land use, you know your map, you're not going to differentiate the two. So though we may have some larger lots behind us, I would argue that that's not the neighborhood. Across from us, and all that in pink, I would argue is the immediate neighborhood, given the context of the layout and topography here. Everything in pink is lots below 150. So when we talk about the context and the built environment, we are more conforming with what's out there today. And as we've heard, to put a larger house here, I think would be out of character. And I think the architect really drove that point home countless times. But when we talk about the essence of what we're here for, we're asking for lot width variances. Across the street, and this is block 713, lot 21, is 139 lot frontage. Lot 20, 137. Lot 19, 137. Lot 18, 138. Lot 17, 128. Lot 16, 128. Lot 15, 122. We're larger than the on lot frontages than those across the street from us. And they are in a zone that requires a greater lot frontage. Now, I say that because in order to grant relief for the C2, the benefits of the application as a whole would have to substantially outweigh these detriments that one may feel by granting the deviations in the variances here. I can argue, I don't really see any substantial deviations with, a substantial detriment here with these deviations. We're looking at 6 feet, 2 feet, 8 feet, imperceivable in the public eye. I don't think it's going to erode the intent and the integrity of the zone. I do not. We are not proposing to put a 7-Eleven here or a Costco. These are single detached residential dwellings in a single detached residential zone. We are putting the use where the use belongs. We are talking about discrepancy of lot width that is really imperceivable by the public eye. I do not see a detriment. A lot of the concerns that were raised would be otherwise a detriment, right? We're talking about stormwater management, we're complying. The removal of the trees, 30 trees are coming down, a little bit more. While sitting there listening, we have 42 trees coming on site, 5 street trees, and then the buffer trees are 23. Collectively, there's 70 trees coming on site. That was my initial calculation. I know there was some discrepancy about the actual count of trees being removed, but I have a net gain of 70 trees. 70 trees being implemented, plus the 39 various shrubberies that they put on their landscape plan. So I think when we talk about environmental degradation, we've brought the properties forward. We're not on the knoll. I think the developer and the applicant would love to be on that hill to get those scenic views that are out in the distance. We brought them forward. We understand there might be some impacts below, stormwater management, the buffer zones, steep slopes. We brought them forward. When we look at this application, I do not see any detriments to the surrounding properties. I know there were some concerns about the neighbors still having access to views and so forth. I do want to remind the board and everybody here tonight that the applicant could put a fairly large house in the respectable location, and it would not be in front of this board. It would not have gotten a notice to the neighbors and so forth. They would just went to the building department and pulled permits. And all of the concerns that we were talking about by way of views and tree removal and so forth, they wouldn't be up for discussion. So I want to just point that out there that, you know, though we are here to look at everything and turn over every rock and look at everything in great detail, the scope of this application is for lot width variance. No other variances have been triggered. Everything else would be in conformance with the requirements by Bridgewater Township Code and ordinance here. So the tree removals, that will be reviewed. and looked at in accordance. Stormwater management, your engineers are next level. That's going to be in compliance. Anything out of the ordinary, the bases have been covered. We are really here for the C2 relief, the benefits here. What are those benefits? We're providing new housing stock for a growing population, homes that are built to applicable building and fire codes. We have the more efficient use of land. We have oversized lots and lot areas and lot width. So we have more efficient use of land. We're also going to draw in appropriate densities and appropriate locations. And we talked about the densities in the FAR. We're also going to look at adequate light, air, and open space. We're not asking for any setback variances. I know there was some discussion on the front yard and side yards. There's no setback relief being sought here tonight. When we talk about purpose I of the municipal land use law to have a desirable visual environment, I do think these 3 lots are more desirable visual environment for that immediate neighborhood, especially particularly the neighbor, than versus one fairly large house or possibly 2 very large homes. So I do think we advance many purposes of the municipal land use law. From a negative standpoint, the detriments, again, I do not see a substantial detriment with these applications. I do see a lot of positive, a lot of benefit here. And as far as, sometimes development is not pretty. We have to take down trees to develop. We have to, find creative solutions for stormwater management as regulations increase. And the red tape gets implemented, from the higher ups and NJDEPs in that regards. And I also want to just point out here, when we talk about this application, what we have here is an applicant who, took back what could otherwise be a fairly impressive property, an impressive house, and they figured this is more suitable for the neighborhood. So when we talk about looking out for the general character of the neighborhood and the community, I think the applicant did that way before we got here, and with the prior discussions on what if I did subdivide it? This house does not fit in this neighborhood, right? So when we talk about the integrity here in the neighborhood fabric, and that's really what comes back down to the Kaufman case, is you can grant the C2 relief with the understanding that this is more in character with the neighborhood, this deviation, this slight deviation. And in the Kaufman case, they put on, much what I just did here, surrounding properties that were deficient in lot width. So granting the relief for lot width, because it is in character and keeping with the neighborhood, can be seen as a benefit. And you do have grounds to grant that relief here. What I also want to point out here is when we talk about the lot width deficiency, what we're not talking about is lot area. The lots are conforming sizes even with the deficiency in lot width. So with that being said, I'll conclude. I don't want to belabor the board unless council.
I just have a couple very basic questions. So under the C2 criteria, I'm going to speak to the positive criteria. It's true that you only need to advance one purpose of Section 2 under the MLUL, correct?
Correct, yes.
And you've listed a myriad of purposes under Section 2 under the MLUL that it would be advanced to the community by way of this application.
Right, so when we talk about advancing the MLUL, they don't number them, they letter them. So we can make an argument we're advancing purpose A, which is to encourage municipal action to guide the appropriate use or development in all lands in the state in a manner which promote the public health, safety, morals, and general welfare. I think we can point to a large amount of what we discussed in these past 2 hearings as keeping with the public morals and general welfare, and safeguarding that by way of moving the houses forward by complying with the steep slopes and the stormwater management and so forth. These buildings would be built, like I mentioned before, to applicable building codes, which over time they do evolve. But with that being said, we could also talk about purpose C, adequate light, air, and open space, as we do not require any setback relief, side yard, rear yards, and so forth. We're not encroaching on that. We could talk about purpose E, which is establishing the appropriate densities and appropriate locations. We are not seeking a density variance here. Purpose G, to provide sufficient space and appropriate locations for a variety of uses for both public and private, according to the respective environmental requirements in order to meet the needs of all New Jersey citizens. We're not going into the steep slopes. We're not going into those buffer zones. We're respecting those constraints. Purpose I, desirable visual environment. And purpose M, which would be the view of lessening the cost of such development for more efficient use of land. There's no need to go into virgin wilderness to build a home. We have a suitable residential neighborhood. We have sewer, utilities, and everything right here. So it's certainly a more efficient use of land here. So we definitely advanced many purposes of Mr. Land Use Law. Not to steal your thunder, but yes, C2 is also to provide a better zoning alternative. This, in my opinion, these deficiencies, a better zoning alternative than one large lot or two large lots that would have large homes.
And then we spoke about the Sherwood Forest subdivision done sometime around approximately 1957. Are you familiar with that discussion this evening?
Yes.
Okay. And the lot widths back in 1957 pursuant to that subdivision was 150 feet in width. Is that accurate?
Yes.
Do you think that this application essentially restores the lots to their original size that was construed back in 1957 when this subdivision took place?
I do, and I think what's important to note is as we define the character of that neighborhood, though the cross street is a different zone, this is the character of that neighborhood, and it's more in alignment with that. You know, when I look across the street at my neighbor's house and it's 50 times larger, the lots are larger, you know, that's my neighborhood, right? But if I can look across the street or drive down my street and there's some continuity here, I think we certainly restore the intent of that zone.
And then just one final question. So there was a lot of conversation and discussion tonight about stormwater management. In large part, that's one of the reasons why the conceptual drawings were included on the plans. Is it your understanding that the 2023 stormwater management regulations are much more onerous than what previously existed?
Everything today is next level, whether it's stormwater management, whether it's building codes, whether it's fire codes, everything building today is modern. Whether it's 20 years ago, whether it was 35 years or 40 years ago, you know, today these regulations, you know, they really do safeguard the public, and they've really picked up on prior generations of development and fine-tuned that. So these properties here, if there is a stormwater management issue, a runoff issue, these properties would be, in my opinion, and you know, I'm not the engineer, I have to stay in my lane, but in my opinion, these properties would be state-of-the-art for this neighborhood as far as, you know, these concerns of stormwater management.
And then staying in your lane as a planner, in the sense that the existing lot coverage is more than what would be accommodated by way of this application. Do you think that plays in at all? Because let me just lay a foundation for the basis of the question. You have a vacant lot now, and you have an existing lot coverage that is over than what's permitted in the zone versus an application that's 3 lots, but will be less than what exists on 1 lot.
And yes, I concur with your statement, and I think that also is the undertone of just how big these properties are and how big these houses, and you know, to get up to that knoll, the extensive driveways and so forth. So to kind of bring this back, we definitely alleviate some of that. But I think it is an impressive feat that we have a vacant lot here with 2 homes. Now we have proposing 3, and there's less of a lot coverage in the cumulative measurement here. So certainly less intensive by way of that. But the stormwater management, the lot coverage in that regards, I think the best thing here, particularly for the resident that lives behind it, is pulling that forward and so forth, because steep slopes do matter. But the engineering here on the site, I don't believe there's going to be any adverse impacts here. And I'm not the engineer, and I have to rely on my colleagues and other professionals for their foundation before me. And from the banter that went back and forth and discussions in detail, I believe engineering has been covered in great detail. There will not be any substantially adverse nature of stormwater runoff. Bringing those houses forward, water goes down gravity, we're staying away from the knoll, those streets are remaining, there's water enhancements, improvements, stormwater management. I don't think there's going to be any impacts here. So with that, I'll conclude. I believe the application warrants approval and that the criteria has been met, and are open for any cross.
Thank you, Mr. Dougherty. I'd like to open up to the board for any questions for the testimony just heard.
Mr. Chairman, I have some questions.
Councilman.
I'll try to get them all in one shot, but I can't guarantee that. I like to look at cases like this by the numbers and proportions. Those are very important to me. now if I'm not mistaken, and I'm going to round up and round off a little bit. Well, this one I won't. We have 106, between all these lots, we have 164,891 square feet. Correct, is that correct?
Yes.
I mean, I just added, the two existing. I take 15% of that, and whether there's 1 lot, 2 lots, 3 lots, 12 lots, we can accommodate 24,000 and change worth a house. 24,733 to be exact. I just took the 164,891 and multiplied by 15%.
I trust your math. I'm following you.
Okay, oh, yeah, please trust the math.
Okay.
I'm not trying to mislead you. I'm just
following.
All right. So am I right in thinking, look, we could make this 1 lot theoretically, and you could have a 24,000 square foot house on it. It could be 2 lots, and you could have a pair of 12,000 square foot houses on it without need for relief. Or you could divide it into 3, and you could have 3 homes up to 8,000 feet without having to seek relief for FAR, correct?
I believe I'm going to go with you, yes.
Right, okay. And I'm not trying to mislead you. I'm just trying to, kind of move us hopefully in a rapid direction. So focusing in on this document I have here, this is the final plat showing the building envelopes. So since this is a lot of property, so the building envelopes are substantial.
Yes.
Correct? So what's shown here is the 3 lots you propose. If it was somehow subdivided in half and we had 2, the building envelopes would be even larger.
In the
right?
3, correct.
Now, when we call it a building envelope, you could build anywhere within that envelope without needing to come to a land use board. You'll get a permit to build.
Yes, with the caveat that more times than not, the front yards have to be of the prevailing average for the street.
Okay.
You don't want one house forward at the front yard
So,
setback, 20 yards back.
I'm just for a moment, I'm trying to understand, is 2 lots here better? Is 3 lots better? And I guess what I'm thinking is if 2 lots are better, you could build much larger homes much further away from the street than if you had 3 lots. Is that sort of conceptually correct? And again, if it was further from the street, it's going to run the risk of blocking more of the view from the lot to the west, correct?
Right, and I'm glad you're bringing this up because from my perspective, from where I was sitting, the big concern that I first was under impression was views and, and preserving views or allowing for views, whichever. So to answer your question, whether it's 1 lot or 2 lots, the houses could be larger. They would not be in front of this board. They could get a building permit, and they could essentially plop it, and there would be no discussion about views and in that regards.
And there could be highly negative consequences to the homeowner directly to the west.
Yes.
Okay. Now we're at so turning attention to the 3 lot condition.
Can I just ask on the 2 lots? So if it remained the 2 lots, would that trigger any stormwater management?
I'm not an engineer, but
Okay.
if you're going to build today, you're going to have to be in compliance with the stormwater management protocols and regulations. If I'm not mistaken, where's the engineer? No? Okay, then there would be no.
Depends on the area of disturbance, so how much. So likely if they were just developing the secondary lot, they would not trigger stormwater requirements.
There you go.
But because of the major subdivision request, it triggers.
Because the disturbance is over an acre, Mr. Peck has been taking it, but yes, so that's what triggers it, the nature of how much you're disturbing of the land.
Sorry, I didn't.
No, it's all right. We're all trying to advance this together. All right, now I'm looking at the grading and soil erosion control plan, sheet 6 of 9, for the purpose of, there are 3 conceptual homes located on it.
Yep.
And those homes are approximately in the 4,000 square foot range.
My font's too small to see that.
I mean, that's a question for Mr. Stiers, because he prepared it. This is sheet 6 of 9. I'll sort of hold it up. The homes that were placed there, again, not exact homes, but for illustration purposes only, are those anticipated in like that 4,000 square foot range?
Approximately, yes.
Okay. All right. And again, based on this conversation we've now had, they were specifically moved 100 feet closer to the road, maintain a more consistent frontage, not harm views from other property owners, correct? That was what you were trying to accomplish with this plan?
Yes.
Okay. So going back to the 3-lot condition, and talking about frontage, so we have 433 feet of frontage roughly. This is where I might round off a little bit. 433 feet of frontage. So am I to understand, well, if you were to split it absolutely evenly, you'd end up with like a 144, a 144, and a 145. You chose not to do that. You chose a 143, a 148, and a 142, correct?
Yes.
So they're almost equal, but not exactly.
Correct.
All right. On the other hand, you could have created a 150, a 150, and a 133. We would not be here. Well, we would be here because it's a subdivision, but there would be no relief sought at the 150, no relief sought at the 150, and then arguably slightly more relief sought at the 133.
Correct.
Okay, so now my question from a planning standpoint, because I know there was conversation that was referenced from Scarlett Doyle, and I'd like to make sure that the people in this room are on the record properly. Is it your planning opinion, and I'm going to ask the same question, that given the choice between 144s or kind of your plan, 143, 148, 142, relatively similar, or to have two that are conforming and one that's more severely not conforming? Can you describe why the three that are slightly non-conforming is a better approach than the two that are conforming and the one that needs more relief?
I will just say this, the one that would be substantially undersized by lot width, I think as the opposing counsel demonstrated, a lot of the surrounding properties are larger. So you're going to have this kind of sandwich and packed in here, and then you're going to have, larger lots. I think it's more visually intrusive and out of character, out of place. And this particular layout here is imperceivable from the naked eye.
Okay, and your point of view there?
That would be my similar perspective, is that, while normally you'd like to lower the number of variances, because logically that would seem like you're planning more within the confines of the zoning, the zoning is irrelevant when you're driving down the street. What you're going to notice with the way the lots are configured is if anyone puts up a fence between the properties, the way the houses are situated, that likely the deviation of 20 feet or 15 to 20 feet on that single property where two are conforming and are 150 feet each is going to be noticeable. 20 feet will be noticeable to someone's eye, naked eye. 6, 8 feet won't be, especially if the three of them are,
Unison.
And flexibility on what someone would ultimately want to do with that property would be lessened because they're already starting at a less wide lot.
As I mentioned earlier, they would still be able to meet the setbacks with the proposed and have some wiggle room with what the box basically that's been shown on the plans for the building footprint. So likely it would reduce the lot area a little bit as well, but they'd still be able to meet the setbacks. So I don't think that's a real concern. I'm more concerned about how that one would stick out and would be probably visually able to notice it, whereas when you have the three in sequence that have a minor deviation from 150 feet, no one driving down will notice the difference that it's 150 or 145 feet.
Okay. And I think this may be my last question. Thanks, everyone, for your indulgence to try to get everything together. You talked about the concept of neighborhood, and I buy that Mountaintop Road is the neighborhood. Do you also subscribe to the concept of a sub-neighborhood, where even just a few houses together represent kind of a unified entity that people would look to and say, yep, that's a sub-neighborhood within this bigger neighborhood?
I would concur, yes. I never heard it called sub-neighborhood.
Okay.
but-
All right, maybe that's my own phrase.
Yeah,
I should
yeah.
trademark it. So my question is this: these homes will presumably be built at roughly the same time. They're not, at this presumed price point, I'm sure they're not going to be cookie cutter. I'm sure they're going to be very distinct, but there will likely be rough similarities between them. Is that an accurate expectation?
Personally, I would assume, I don't like to assume in this line of work, but yes, I would assume that given if you're building 3 homes, you get the wholesale price on, certain materials and concepts in that regards. I would imagine there'd be some similarities there, but how similar? I haven't seen the proposed concepts. If the board proposes them to be uniquely different by facade, that's...
Yeah. The reason I'm asking the question is for the person that's driving or walking down the street X number of years from now, and they walk by and they see 3 homes that are, roughly the same, they were built around the same time, they're roughly the same, dimensions and all that, does that create a positive visual appeal, as compared to the approach where we're going to say bigger and squeezed in?
I think when we talk about big in size for buildings, I think it's a better visual than to have this towering giant next door to you. But as far as aesthetics, I do think it's a little anecdotal. Your perspective of what makes aesthetically pleasing neighborhood may be different than mine. I personally do not like when every single house looks exactly the same. That's why Purpose I is a desirable visual environment through good creative design and arrangement and techniques. Whether that means one has a portico, one has that kind of ordeal, or columns, or 1 garage, 2 garage, whatever that is. But by way of scale and massing in a house, I do think larger homes should be with each other, and smaller, more modest homes should be with each other. That's why we have FAR. Typically, FAR was for warehousing in that regards. We've seen that come over to residential. Why? To stop these parachute McMansions dropping into, because we've met the lot area, lot width, setbacks. But here we have this massive house because they found some loopholes. So I do think, by way of answering your question, size and scale of houses that are relatively the same, close to it, are more aesthetically pleasing than larger houses mixed with tinier or more modest homes.
Okay, thank you for your indulgence.
Councilman Kirsch. Any other questions?
Mr. Chairman, I have a few. Mr. Doherty, could you refer to that tax map like you did earlier? Just want to ask you questions about the frontages of some of the other lots. So, lots, again, 49, is that, what's the frontage of lot 49? Which is, okay, and lot 48?
150,
47,
150.
okay. And then to the other side, lot to the east, 52.01.
52.01 is 106.
106. And 52?
Is going to be 106.
And 53?
53 is 177.
Okay. Going on the other side of Mountaintop, lot 15, what's the frontage of lot 15?
Lot 15 across the street,
Yes.
122,
Lot 16,
128,
lot 17,
128,
lot 18,
138,
lot 19,
137,
20,
137,
and 21.
136.
Okay. Thank you. So I guess my question for you, sir, would be, with the varying lot frontages, 2 different zones, you have 3 new lots that are proposed to be frontage of 133.5, 147.8, and 141.8. I asked earlier about if this, Mr. Stiers, if instead of 3 lots, created 2 conforming lots of 150 each, and then the other one was like someone said 16 feet, so it would be 134, 133. When you take into account all of the other lot frontages from the lots that you just described, running from 150, it seems to the west, the lots are wider, and then you move to the east. For the most part, they're narrower, and across the road, they're narrower. Is there anything negative about that? Is there anything negative about having 2 additional conforming size lots, creating one undersized lot similar to what is directly adjacent to the east in 5201 and 52? I guess that's my question. Is there anything negative about that?
I think the visual impact is the negative impact, is because it would be, in my opinion, my professional opinion, very noticeable.
Even with lot 52.01 and lot 52 being at 106 each. So going from, in lot 53, 177, and you go to east, moving west, 106 for lot 52, 106 for lot 52.01. It was suggested that the next new lot could be 133 feet, and then having 2 150-foot frontages, and then so on, moving west. So your proposed, my concept here that I'm putting forth and just trying to get some reaction, I'm going to ask Ms. Sarmed for her opinion. Is there anything negative about that? Creating, instead of 3 undersized lots, 2 undersized lots, 2 conforming lots, 1 undersized lot. Is there anything negative about that from a planning perspective?
Well, I said it again. I think the visual will be the negative here, because it would be extremely visible from the public realm, the naked eye, that's a smaller lot. As you see the larger lots kind of come at the bend, and you will have that sandwich effect. I think when we look at the deficiency here, we're at 143, 147, 141. Some of the lots across the street are comparable. They're in the 30s. Some are a little smaller. They're in the 20s. But by way of making 2 of them 150 and one of them, say 130, this arrangement is, you wouldn't be able to pick it up. You would just drive through. They would look 150, in the public realm, but that 130 would look 130, if not more drastic.
And the reason I asked the question is because I'm trying to weigh that the township has an R40 zone. And there's standards. And if we don't try to adhere to standards wherever possible, then why do we have this area zoned R40?
So lot width is one of those unique dimensional requirements where...
It's a standard.
Yeah.
It's a standard. Every zone has a standard for lot width.
Yeah.
So it's not unique to the R40
Well, I'm
zone.
saying it's one of those bulk variances where when we talk about the zone, sometimes the lot width is very important, but there's some features, whether it's a curve or in that regards, or prior subdivisions in that capacity, where you may not get the lot width. But when we talk about the zone itself and really what sets the foundation for all the other bulk requirements to be built off of that is the lot area. It directly affects. So when I hear the term R40, and I love when municipalities do this because I already know it's 40,000 square feet.
Mm-hmm.
So when we look at the essence of that zone, they're larger lots. Now, can you get a lot deficiency on width and fan out and so forth? But to have that area, that room, that elbow room, that adequate open space, for me, that lot area when we talk about the zones in residential zones is important, because we can look at very similar application that I believe I was just in front of this board, where the lot area may not have matched. We had lot widths that were deficient, but they went miles back and the area fit. So, when we talk about what is more important and the intent of the zone, I would like to argue that the lot area, the size, because we can have 150 square foot width frontages, but 20,000 square foot lots, right? So when I see the essence of the zone, that lot area, in my professional opinion, sets the foundation, is more important to hold sacred than I think a lot width, particularly at these numbers, because the lot area really deems the size, the scope of the build-out, the adequate, like I said, the setbacks and so forth. And if this was substantially undersized, which I don't believe this is, by lot width, 120, 115, 100, then yes, I would argue that this is eroding the intent of the zone plan. We're talking 141, 147, in the ballpark of 150. Imperceivable. I don't believe there's going to be a disruption in that zone fabric going up mountaintop.
One last question, then I'm going to ask Ms. Sarmed to answer the same question. I understand your perspective. You're saying that the area is probably a more important feature or standard. I appreciate you offering that opinion. What's the percentage? What's your philosophy, both generally, because you're a planner, but for this application, I'm assuming your philosophy would not just be applicable to this application. What is your philosophy about what percentage is a de minimis reduction in the standard?
I think it's relative, to be quite honest. You would cite specific characteristics in that regards, neighborhood build out. I honestly, I don't have an arbitrary number to put on it.
Okay, that's an answer. Okay, thank you.
Yeah.
Sarman.
You want me to answer your first question and the second question?
Sure, both.
I don't necessarily share the same perspective as Mr. Doherty. I do think that a deviation from zoning alone doesn't necessarily rise to a degradation or a counter to the purposes of zoning. And I look more globally at the purposes of zoning. So the R4 zone, in all of its bulk standards looked at collectively, create kind of the character of that zone. However, there are lots that are oversized, such as these. There are lots that are undersized. There are lots that have deviations from width. So lots they're not all standard, even though the zone prescribes it that way. Not every lot has enough, and some have too much. And so when I look at deviations, you also have to look at how a lot with deviation might impact other bulk standards. It may impact the lot area. It may impact the setbacks on the building. It may impact the coverage, So I look at all of those together to see if that's a deviation and contrary to the zone and the purpose of the zone that's put in place. And with that, your second question about what would be considered de minimis, I personally never use the word de minimis simply because every board treats a variation differently. Every board that I represent or I stand before can hold the bulk standards to whatever level and a deviation from them to whatever level. It can be 0.1 away, 0.1 feet away from a deviation, and every board looks at that differently. So I never call it de minimis, whether it's small or big from a numerical standpoint. Because it can be small or big to a board, depending on what their zoning and what their master plan regulates and how they've, dealt with it over time. If their master plan has a goal that says we should not be allowing subdivisions that have lot width variances, there you go. That's what sets the standard for the township, for the municipality. And so we didn't really get, and I'm just kind of segueing my answer into some of the testimony, we didn't really get any kind of evaluation of the master plan, nor did we get, I think, testimony related to one of the requirements for the C2, maybe I missed it, about how this represents a better zoning alternative, which is a requirement established by the Kaufman case. And so I'd like to hear that because I think it does answer some of your questions and also at the same time presents the testimony that's required as one of the proofs for that variance. So if Mr. Doherty could, I think under the Kaufman case, should be also including how does this proposed condition present a better zoning alternative for the property, and that for the board's edification, that means not just the purposes of the owner will be advanced, so creating 3 buildable lots that could be sold, but rather how does this benefit the community as a whole?
Right, so the community as a whole will be advancing the purposes of municipal land use law, which I went over in detail and called them out. As far as advancing the purposes of a better zoning alternative, if you will, I did circle back to that because I felt council was going to, bring that up. This, in my opinion, is a better zoning alternative than strict adherence. We do have a growing community, housing, and so forth, more efficient use of land, which circulates back to the advancing municipal land use law. So to allow this deviation, I do believe is a better zoning alternative here than to, let's say, the proposed concept, to compliant, one substantially shorter, or just one fairly large lot, one fairly large house, or 2 fairly large lots and 2 fairly large houses. So by way of advancing a better zoning alternative, it really does come in a more holistic approach when we look at what could be there and what is out there as far as the neighborhood. So I do think that when we talk about a better zoning alternative here, it is a better zoning alternative to have more modest homes here on these lots at, as I read them off again, 143, 147, 141 versus the compliant or the alternative, the larger. So I do think this is a better zoning alternative at a holistic approach of what could manifest on these properties. As far as the intent of the master plan, again, this is a residential neighborhood, residential zone. Master plan speaks strongly in preserving the character of residential neighborhoods, and again, this application does that. Again, I do think the board can look at this application favorably with little to no detriment with the proposed. Yeah.
I could just follow up and ask, did you notice any 25,000 square foot homes in what Councilman Kirsch characterized as the sub-neighborhood?
No.
No. And did you notice any 12,000 square foot homes in what was characterized as the sub-neighborhood?
I think it's more in line, closer to 12,000. But I don't have the actual ruling.
Wait, no. Let me ask it again. Did you notice any 12,000 square foot homes in this sub-neighborhood existing?
No.
Okay, so there's no 12,000 square foot homes in this sub-neighborhood.
From my understanding, I don't have every
The sub-neighborhood,
house.
what we spoke about.
Yeah. I don't
this
have,
evening.
Council, I don't have everyone's property in their houses.
But
Generally speaking.
You've seen aerials
yes.
this whole hearing, so you can say with certainty that there is no home in the
Confidence,
sub-neighborhood.
yes.
Okay. So I asked you earlier whether I should ask, as an alternative, a better zoning standard, consider whether the municipal land use law is advanced?
Yes.
Okay. And you only need to identify one. But
Correct.
as Ms. Sarmad pointed out, it must serve the community at large.
Correct.
And you cited that this application advances purpose I, right?
Desirable visual environment, yes.
Now, I just asked you a number of questions related to the scale and size of the development from the standpoint of a community. Would you agree with that?
Correct.
Or at least looking at the sub-neighborhood?
Yes.
Would you agree that by way of this application, the board is actually controlling and advancing purpose I by ensuring that the scale is appropriate based upon the surrounding sub-neighborhood?
I would, and that's why I mentioned a holistic approach. With this deviation, we have to look at what comes with this deviation, and without this deviation, what could manifest there. So yes, I concur, I agree.
And this is a permitted use?
Correct, residential home in a residential neighborhood.
You don't have any issues with density, single family, right?
No FAR, no lot coverage, yeah.
Okay.
Mr. Chairman, I actually do have one other question related to what was just discussed. We talk about, proportions, and that's very, very important. I guess maybe there's a question really more for the applicant. What we're seeing here, I'm again going to refer back to the grading and soil erosion control plan, sheet 6 of 9, only because it has, the conceptual, homes placed there. What I don't think we would want is to have, the building envelope permits and the size of the property permits, we're going to build 3 8,000 square foot homes. I think that would not represent what you at least have on paper and what we anticipate might occur in this neighborhood. would your client consider as a condition some shrinking of the building envelope that will essentially, ensure that you could still build, a nice size home, but would provide some assurance to us that we're not going to end up with 8,000 square foot homes?
Your ordinance will already ensure that that the developer, it is impossible to develop conforming homes that are 8,000 square feet. It's not.
Well, I think you could.
The floor area ratio will actually restrict it based on the hillside development calculations, will restrict the homes to what is shown on their zoning table. So 7,000, 6,000, 5,000, total square feet, not building footprint, basement, finished basement, first floor, second floor.
We've demonstrated the worst possible scenario. This is the most developed the property can be. We've conceptually shown the worst possible scenario.
Didn't Mr. Stires, I think he said the maximum FAR is 6975 for one of the lots, 5958 for one, and 6161, right?
That's correct, and that's not footprint, that's FAR. So if you're building 2 stories, of course the footprint would be much smaller. I would imagine that these will be at least 2 stories.
Their hillside development calculations for their impervious coverage and their FAR will basically dictate how big the building footprint can be and how many square feet total the house.
I guess where I'm going here is there was conversation about how we move the homes closer to the road. So they're going to be about 100 feet from the road. That's going to be in line with the rest of the neighborhood. It's also not going to encroach, potentially, not going to encroach on the view from the neighbors' homes. What assurance do we have that that's really going to happen?
The developer and the applicant has made an application for a subdivision and is requesting variance relief for lot widths. The concerns that are being raised right now over the course of the hearing have absolutely not a shred to do with a lot width variance, nothing whatsoever. The developer has shown possible building envelopes that conform to the township's ordinance. This is what the ordinance allows the developer to do. Now, I understand that there's a lot width variance, but all of the other things we've discussed this evening are things that are way outside of the variance relief being sought and the possible detriments associated with the relief being sought.
Well, but they're related, because if we don't provide the relief, then we don't have those potential negative consequences.
I totally disagree with that. I think the point of the testimony that you've heard this evening is that the alternative to this is that this case doesn't go before the board. And all of the things that we've discussed is not going to be included in a resolution. I don't want to use the word encumber, but will not restrict the use of the property. Because we're here, the board has the opportunity to say, you can have a home that it has the maximum FAR of the numbers that were just listed, the maximum lot coverage numbers that were just listed. The board has the opportunity to control stormwater management on the property. I don't want to provide testimony, but I think that we've heard that it's an improvement to existing conditions. It would be subject to the 2023 stormwater regulations, which are much more restrictive than currently what exists on the property. So by the applicant coming forward, presenting this to the board, again, I don't mean to stray off course here, but when I use the term de minimis, I'm using that term in relationship to whether it constitutes a substantial detriment or a substantial impact. So I've classified the variance relief as de minimis because as we've heard this evening, none of the variances that are being sought would be discernible to the naked eye. No one would be able to tell that these variances were being granted this evening.
No, I understand that portion of it, but ultimately, we as a Bridgewater community, the people that live on this street, they're gonna see this, whatever is built. And I guess I'm just looking to understand what, if any, protection we as a municipality, we as a community have, that, what is built ultimately looks something kind of like this.
Mr. Kirsch, if I may.
Ordinance.
I was going to say something similar with what Mr. Silbert brought up, was that this application is for the subdivision, and we are talking about something that isn't going to be under the purview of this board. Eventually, when it goes for building permit, the homes won't have to come for site plan necessarily. But this board, what they are able to do, and we have been doing, is talking through the consequences of permitting the variance, which I think you have every right to do. You're looking through what are the potential consequences. And I don't necessarily think that what Mr. Silbert said about this board is looking over and establishing what the FAR is. The FAR is actually established by the hillside development calculations, which probably pre-existed or came after, this house probably pre-existed, which is why the coverage is over what it is right now. It pre-exists because the hillside development calculations and steep slope didn't come into play. But that new lot next door would be subject to those same hillside development calculations that we're applying here. Certainly, there are other things like stormwater management and other conditions that have been imposed over the course of this hearing that they've agreed to that we are allowed to do as part of this, which is no different than I think what Mr. Kirsch is trying to get at is what can this board have the applicant agree to as far as what can we expect? We're walking through all these consequences, but it's all for naught if the expectation is lost and there's no condition applying it. This board previously, in prior applications that I've approved or walked through resolution compliance for, has imposed conditions about making the stormwater management larger on the site relative to the size of the home. They have restricted the size of the home or the placement of the home. So I wonder, Mr. Peck, and how we can incorporate some of the conversation that we've had, depending if the applicant is agreeable to it, to some of the conditions that we've talked about. You know, the setback. Technically, they're in conformance with the setback, but the setback for the zone is 50 feet. So could they have we imposed a condition that it has to be 77 feet?
The only thing I'm thinking about that could accomplish the goals that have been enunciated here would be some limitation on the house size, a condition. You know, building footprint not to exceed whatever.
And thus far, as I saw it from my memo, which basically said you can't go past the FAR is established by the hillside development calculation, not a square foot over, is what they have agreed to thus far in the response memo.
Well, I don't think they'd have an option. They have to comply with the ordinance.
That's basically complying with the ordinance, correct?
Right.
But, and it's also in the absence of if the hillside development calculations ever changed, that they would agree to that. I don't know if that stipulation was made clear, but that would, whatever is approved as part of this.
I don't see them being liberalized anytime soon, but yeah, sure.
I guess where I'm really going here is I would feel like I have not done my duty if the net result of this is, if the net result, assuming there's enough votes, if the net result is something that kind of looks like this, I would feel that I did my duty. I think that we've had a constructive hearing, there's been good faith, there's been a good back and forth. However, so that would be a good outcome. What would be a bad outcome is that if, you know, we'll know that homes are going to be 7,500 feet and they're going to be 150 feet from the road. They're going to block the neighbor's view. They're going to do all these other things. That to me would be a very negative outcome of this process. So I'm just looking for guidance on how we can get to a relatively winning scenario where, again, assuming that there's a majority of the board, we end up with a condition that looks by and large like this. And not a situation where the homes are dramatically larger or located in a different place on the properties.
Okay, could we say something on the setback of the home? Put a stipulation on it so that it's not further back than what the new overlay that you shared from the beginning. Right? Couldn't we do that?
Can I?
I guess the question really, Mr. Silbert, is the conditions that are shown in the bulk table are not just demonstrative for the purposes of this application. Are they what will be complied with at the time of building permit and no different from that?
That's correct.
Okay, that's the assurance I think the board needs, because I would have the same concern that this was just for the purposes of presenting what a home could look like, and then when it came time to submitting a building permit and each one could come in on its own, that the separate builders could say, well, I don't like it 77 feet, I want to go just right up to the 50-foot front yard setback, or I want to go 150 feet back because I want the views. And so I think as long as we have those assurances that the conditions will be based on the zoning table, on their engineering plans, on their site plans, as revised based on any of the testimony, that's what the board is comfortable with.
I can just, so the applicants told me that we can generally agree to construct the homes in their approximate locations, there must be a little bit of wiggle room. What I'm trying to prevent really is an unnecessary encumbrance on the property that is unreasonably related to the relief being requested, where these conditions do not have anything to do, in my opinion, with the lot width, yet the board is requesting that, and the applicant is agreeing that he will construct the homes as generally shown on this concept plan. But the reason why I'm apprehensive about it is just because in 30 years, if the ordinance changes, or in 30 years, if someone wants to make a renovation or an addition, I don't want to do anything to encumber the property that will prevent that homeowner from doing that. That's my main concern, particularly in light of the fact that these types of conditions would not be reasonably related to a very insignificant lot width variance. That's my concern, and I'm failing to draw the nexus between certain conditions and the relief being requested, where if not for the lot width, this is as of right subdivision, and I believe that if the board's going to impose conditions, there should be a nexus or a relationship imposed or created between the variance relief being sought and the condition being imposed. With that being said, the applicant has stipulated to constructing the homes in the approximate locations as shown on the plans this evening.
And I think the last thing we want to do is to box you in and be like, uh-oh, I need to be 5 feet this way, I need to be 8 feet that way. That is not the intention. The intention is that again, I hate to just keep, showing this to everybody, that something, reasonably close to this is what shows up on that land.
Just, I understand, I do understand the board's concerns 100%. I'm trying to protect my client's interests, and really, I'm trying to ensure that there's no unreasonable encumbrances on the property. I don't want to be caught in a situation where a variance...
They got to come back.
30 years from now, and, they have to remove the condition in the approval. I just want to make sure my client's protected in the long run. That's my concern. That's why I'm tracking this out, really.
Okay. So I don't know, Mr. Peck, if I made life easier or harder of how we're going to condition all that, but... It's going to be a delight. But, that's... I mean, again,
Councilman, my biggest concern or my apprehension is that you have your ordinance, and if the applicant ever wanted to depart or deviate from it, they have to go back to the zoning board. So that's my major concern is that.
Well, and I think my position, maybe others, is it depends on what you want to do. If you want to do some, since these are large properties, is there a pretty decent amount of wiggle room to do what you want and get a building permit in the future without triggering relief? Probably. But, at some point, if you want to do something big, maybe you will.
Right. And that's exactly why I raised the issue that I perceive that as of right, the applicant can do so much to the property just as of right.
Okay.
So I don't know if we land, I think we can probably craft something, I think Mr. Peck.
Well, I mean, that they'll construct the homes as generally depicted on the plans.
And I think.
And they'll conform with the zoning table that's on the approved plans.
That wasn't that bad. Well, I think just the zoning table that's on the plan may be less restrictive than the hillside ordinance.
No, it is, no, it
Much more
includes,
restrictive.
it includes the,
They have two different calculations, one without the hillside and then one with.
This required provided on sheet 1-9, is this the hillside ordinance or is this?
I don't think that the zoning table was updated to match, I believe from the first hearing that the steep slope calculations had changed, actually. They had rerun the calculations based on the contours they'd used, the intervals, and I don't think your zoning table actually matches, which is a good catch, it matches the steep slope allowances.
The applicant has stipulated to complying with the township's FAR requirements.
Mr. Silver, I think you're just misunderstanding. It's a housekeeping issue. Those will be updated as part of, when they come for resolution compliance, these plans will have to be up to snuff as far as those numbers. So they will have to match what's in the steep slope calculation, and that will be updated in the table when it comes to resolution compliance, if that makes sense. It was just, your steep slope floor area ratio table on sheet 1 doesn't match the zoning table. The zoning table, as noted below, says as shown on the plan. So what is shown is in the zoning. The steep slopes show what the maximum is done. So what those house plans are shown is what is in the zoning table. No, I'm telling you that they're different. I know they're different. The steep slopes is the maximum. The zoning table is what is shown on the plan. Oh, understood. And you will comply with the maximum, though? Absolutely, yes. Because you're, right now, our plan is, like we said, the general location on the plans. The intent would be to comply as much as possible to what is on the zoning, which would be under the. So this is what's confusing, is your zoning table is showing a value for the FAR, let's say for proposed lot 50.01, that's higher than your HDC calculation below. It is 26 square feet bigger on your zoning table than it should be for the maximum. So that's confusing. Anyway, what I think should be changed in the zoning table is essentially what is shown in the steep slope floor area ratio table, because those numbers are lower.
Again, we'll just comply with the ordinance. We won't go above the ordinance. Again, this is a subdivision, and we're agreeing to comply with the ordinance. So as the ordinance requires us to steep slope calculations, we will comply.
I realize Mr. Silbert might be frustrated by the procedural, that this is a subdivision, and we've discussed, the conceptual buildings, but a lot of the testimony, and this is the problem I'm having with the impasse we're at right now, and I think the board is perfectly fine in the way it's moved forward, and Mr. Peck can correct me in his legal perspective, but I think we're on the right track, is that we heard testimony about visual impact of homes and the alternatives. And so we heard testimony in the alternative, so we have every opportunity, I think, to consider what happens when you have the 3 lots. And so, I don't think it's independently the board, going astray here. We heard it from the applicant side too. So as, if we, even though it's late in the night and we've been at this for a while, I think the board's perfectly fine in considering these consequences and imposing the conditions that are perfectly related to the testimony we heard and perfectly related to the application before us. So I think, I don't know what else the applicant has as far as testimony.
And the justification is that, you end up with 3 lots that, are very viable versus 2 that are viable and 1 that's much less viable. So, I'm trying to get to a solution here, and again, I just want to make sure that we don't look back on this X number of months or years from now and end up with something that just looks a lot different than what it feels like many, if not most, of the people in this room think we're headed.
Mr. Chairman?
If I may, I seem to recall in the past that we made a strong suggestion to the contractor in a development as to the size of the house, as to the footprint, so many square feet. If I remember correctly, it was on Foothill Road. Correct. Are we at that point? Would this be something you'd entertain?
Absolutely not. It has nothing to do with the relief being requested.
Okay.
I'm not trying, I know I'm getting frustrated. I'm not trying to, it's not related. There's no nexus between, we're seeking, again, approximately 8 feet, 6 feet, 2 feet, lot width variances to encumber the property so as to require that the footprint be arbitrarily be a certain size when the applicant's saying, we comply with every single township required ordinance except for those lot widths. I'm not giving on it so easily because there's no nexus to it.
I think I can help here. I mean, there are homes in the area. There's one, it looks like lot 47, 6363 square feet. Lot 49, 22. Lot 52.01, 5880. Lot 52, 6240. 6740. Those are all very similar to the maximum house size that they've already stated, and that's on the same side of the road in the same zone. So I mean, I think I can help in that. We didn't say those lots before Indeed did the work on finding it.
Just to add to that, Mr. Stiers has, I think, confirmed that the home size, I think these max sizes, what were these?
Those are maximum.
Yeah, the maximum size of the home, 6975, 5958, 6161, should be well within the character of I don't want to say within the character, because some of the homes are like 2,800, 2,900 square feet. So, you could take that both ways. But the max in terms of at least that side of Mountaintop Road, those square footage that Mr. Stiers has validated should kind of appease the rest of the board, I would imagine, based on what we have that's currently in existence.
Mr. Chairman, it's 10:30, and I think we still have to have questions from the public. We still have to and Mr. Burr's not here. I don't see how we can finish this tonight.
We're certainly not taking any new testimony this evening, and to your point, we still have members of the public to hear, and I don't think I've exhausted all of Ms. Sarman's questions either. So with that, Mr. Silbert, would you entertain carrying this meeting to a later date?
Sure.
Ms. Probst, what do we have open? That's for 8/6? Right. So 8/6 and 8/20, they're both essentially free to carry this. Okay.
How does that work for you guys? It being August.
I can't make either one.
Well, August 6th, we have those other.
Yeah, but let's see what August vacation time, let's see what their team availability is.
Nancy just wants to get a roll of the board to make sure everyone who's available for the 6th, so that the applicant knows.
6th is again.
I'm going to just call a quick roll who's available for the 6th. Mr. Chowdhury?
Yes, please. Yeah, 8/6 is okay.
Mr. Atkins?
What was the date in question?
8/6? As far as you know? Ms. Corr?
I'm tentative, probably not.
Councilman Kirsch, you said okay so far? Yes. Okay, looks like we would be okay for quorum.
We're good for the 6th as well.
Are we running into, do we need to get a consent to extend time to a date certain? Will you consent to extend time, whether or not it's needed, through August 31 of 2024?
Yeah, that's fine.
Thanks.
Therefore, Ms. Probst, we will carry this to August 6, 2024.
And no further notice, no further notice will be published or served.
Thank you.
Very good. Thank you, Mr. Silbert. Actually, 8/6 worries me.
Well, we have the master plan hearing, and then we have the redevelopment hearing.
Right.
That's on the 6th.
Yeah, but that shouldn't be too much.
This should be maybe another 4
Okay.
Oof.
Hopefully not more.
We are good at belaboring the
Yeah, I know. Jesus. Point no. We got the answer. Ask and answer. I think we should have a ruling. Like, ask and answer.
Transition to
Move on. I thought we actually got some.
We need to tax.
You want to keep it?
Yeah, well, that last bit that Kinder brought up, that was some good detective work, finding like the home sizes adjacent.
Ashley and I were debating, we're like, all right, I think we're just getting down to like how big these things, you know.
Yeah, but it sounds like even if they maxed out what they could get under the ordinance, it's still gonna be consistent with what the neighborhood.
Road, we gave a limitation. It's a different case.
Yeah, but the big thing is, in my opinion, that if we left it at 2, and if we piss them off enough, they're gonna stop it all. And I say, fine, we'll build 2 mega homes backwards.
Fuck you,
Yeah, screw
24,000
that.
square feet of stuff
We're
on
not
the
gonna fix
top of the hill.
stormwater. We're
Yeah.
not gonna do anything like that. And screw you if we flood your home. Doesn't matter.
Put it on top of the hillside.
We're getting the benefits.
Block all your foot.
We're getting the benefit of the wells, dry wells,
Yeah.
the environmental changes of the.
Do I love that it's not
Do we
conforming in the
feel
house?
adjourned?
No, but I think it's better.
Yeah, I gotta hit the head big time.
I need you to eat before I struggle.
No.
Oh,
I was gonna just walk out.
No,
See, I have a bit of ways to go, so I'm always hitting like dimes
I have
and
like
shit up.
7 minutes.
Nice.
Ms. Probst, we've discussed August 6th, and we've also discussed, what's the other date in August? 2020, okay. What does the calendar look like shortly afterwards? Okay. 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 Any other comments? With that, I'll take a motion to adjourn. That's Mr. Pappas.
Second.
I second.
That's quite a few of you. All in
All of
favor?
us?
Yeah.
We're all in
Aye.
favor.
Aye.
Yeah, they're very different. They're like want sidewalks to nowhere and warehouses. I'm like, oh, it is so opposite.